clear. Interim order, no, then maybe continue. Interim order, no.
The interim order passed earlier shall continue till then. Okay.
Highly occurred.
May I, Your Lordship?
Yes.
I beg to mention item number 28, Your Lordship. On behalf of B. Patak, he could not appear today due to some personal difficulties.
Item 28.
28, yes, Your Lordship. Maybe
Hmm?
I'm appearing on behalf of B. Patak, Your Lordship. He could
In
not
which item number?
28,
28.
yes, Your Lordship.
For the petitioner,
Yes.
what you want?
Maybe list this matter after 4 weeks, Your Lordship.
4 weeks. This is for hearing. Oh. No objection.
No, Your Lordship.
Okay. Miss
Tirimi.
Land Council. Your name is there?
No, my name is not there. I'm appearing on behalf of B. Patak, Your Lordship.
Okay. Land Council. Appearing on behalf of Mr. T.
B. Patak.
B. Patak. Land Council for the petitioner. Press for adjournment of the matter
4 weeks, Your Lordship.
for 4 weeks.
Yes.
To which Mr. Togo, you are also appearing here? Okay, Ms. Pangu Lanaga, government advocate for the state respondent has no objection. Accordingly, the prayer is allowed. List the matter after 4 weeks. Okay.
My lord, I beg to mention item number 8, my lord, with the consent of the other party, my lord, let this matter be released after 3 weeks, my lord.
Affidavit not yet filed.
Not yet filed, my lord. That's why, my lord, we need some more time, my lord. I've taken consent from the other party, my lord.
No,
Karyam,
I'm not
K.
here.
Karyam.
No objection.
I'm not
Oh.
here.
Karyam, man, here
Not
consented.
there. Okay. Mr. T. Togo, Land Standing Council for the Education Department with the account. Sir. And then praise for father.
Father, my lord, 4 weeks time, my lord,
Father, 4 weeks time
to file counter
to
affidavit.
file counter affidavit. He has also obtained consent from the
other-
Land Council for the petitioner. So, in view of the above, when I prayed for comma, further 4 weeks time is granted to the respondent to enable him to file affidavit in opposition. Okay,
Deeply.
this is according after 4 weeks. Okay.
May it please, my lord, may it please, your lord. Yesterday, my lord, due to paucity of time, my lord, one writ petition could not be registered and listed in the court number 5, my lord. So small prayer before your lordship is for permission, my lord.
Okay.
Being the station senior, I have to seek permission.
You want this matter to be listed before?
Court number 5.
Okay. This is what this matter is about.
Hearing, my lord,
Okay, due to paucity, it could not be.
Yeah.
Okay. Then I have to inform.
Court to lodge.
Court number 5.
So the case is, this is criminal,
No, no, my lord.
civil,
Writ petition.
part hard.
It is review, but some
Okay, but then,
new, with a new ground, I been directed to file the press.
okay. So for when? Today?
No, no, in a court number 5, yes, today.
Today?
Yes, sir. It is already listed there
Already listed means?
in the cause list. But the repetition has not been listed because of the due to paucity of time.
Okay, it's similar matter is listed.
Yeah,
Okay. Then inform, huh?
obliged.
Item number 2.
May I please, my lord?
Yes.
My lord, this is a contempt petition, my lord, against the LS contemptor for its willful and deliberate non-compliance of the order dated 1/6/2026, my lord. My lord will find the order in page number 9, my lord. My lord, this is a consented order, my lord.
Okay.
Consent order.
Okay.
My lord, the LS contemptor, my lord, he was supposed to pay rupees 11 lakh
Okay.
within a period of 45 days.
So a copy was received by him.
Yes, my lord. My lord, he is the petitioner, my lord.
Okay.
However, my lord, we have also sent a copy of the order. And he is in receipt of the order, my lord. Through registered post, my lord.
Mhm.
My lord, item source delivered. My lord will find that in page number 59.
But it was passed in his,
In presence of his,
in the writ petition filed by him only.
yes, my lord. My lord, there was a consent order.
Okay, okay. Third, Miss,
M. Karwa.
learned counsel for the petitioner, staff on para. This is an application filed under Article 215 of the Constitution of India, read with Section 11 and 12 of the Contempt of Court Act 1971 and Rule 9 of the Contempt of Court, Gauhati High Court Rules 1977 for non-compliance of the order dated 1/6/2026 passed in WPC number 140/2022. Staff, issue notice. Returnable by 4 weeks. Staff, the petitioner shall take steps for no service of notice upon the respondent by a speed post as well as by usual process within 4 days from today. Okay. List the matter after 4 weeks.
Highly obliged.
Okay.
Item number 3,
Yes.
it's lucky that this matter is listed before you also. It pertains to this violation of principle of natural justice and violation of this scheme of this Arunachal Pradesh Civil Code Act 2021, my lord. That's why it would be easy, easy for your lordship to make a positive decision immediately, your lordship. My lord, our this moot point is the ADC in the present regime of this.
It's in the form of writ petition,
My lord,
not revision
no, my lord, writ petition, my lord,
Hmm.
writ petition.
against the order passed.
Or against the order passed, my lord. In tune order is in page 63, my lord. Page 63. May I read, my lord? Page
Hmm.
63,
Page 63.
my lord.
Yes.
Whereas a complaint dated, your lordship, please see the order dated. This order was also passed on 31st July 2026. And complaint is also stated to have been filed on same date, my lord. Whereas a complaint dated 31st/7/2026 has been received by the undersigned from Sri Naksha Perme, Chairman Ayeng Village, Koyo Area Community Land, and Sri Naklom Mori, Secretary, Koyo Area Community Land, Ayeng Village, regarding the Kerbang order issued by the Kapok Lagu, GB and Kerbang in charge Ayeng Village. Whereas the complainant states that the Sri Kayon Perme of Ayeng Village had approached Sri Kebuk Lagu, GB, seeking the conduct of Kerbang between Sri Kayon Perme and Ayeng Bane Kerbang in connection with a disputed land situated at Koyo area, Midulireng of Ayeng Village. Whereas the Sri Kebuk Lagu, GB and Kerbang in charge Ayeng has issued a Kerbang summon on 27/7/2026, fixing 2/8/2026 as the date for conducting the said Kerbang. Further, on careful perusal, it is found that Sri Kebuk Lagu in charge Ayeng Kerbang is himself one of the complainant against Sri Kayon Perme, having affixed his signature and official seal on the complaint letter dated 10/7/2026. Whereas, upon examination of the record available, it is observed that the land dispute relating to the Koyo area of Ayeng Village has already been adjudicated through multiple Kerbang proceedings. Ayeng Kerbang decision 22/10/2015, Ayeng Kerbang decision dated 28/8/2019, Bogum Bango Kerbang decision 18/2/2026. Whereas the matter has been decided in the Bogum Bogum Bango Kebang, which is a higher customary court, and the same cannot be reopened or re-educated by the village Kebang unless directed by a competent court or the competent authority. Now, therefore, Sri Kebuk Lago GB and Kebang in church, Ayang village is hereby prohibited from conducting the proposed Kebang scheduled on 2/8/2020 in respect of the aforesaid land dispute. It is further directed that Kebuk Lago GB and Kebang in church, Ayang village shall refrain from entertaining or educating any matter that has already been decided by the Bodum Bangok Kebang or any higher competent court authority unless specifically authorized or directed by a competent.
Yes, I think
My lord.
it cannot pass.
Yes,
Such order.
yes. Admittedly, Lordship, because the Gambura, that forum is the judicial authority.
Mhm,
That cannot be prohibited
mhm.
because the power to decide on the issue of jurisdiction also rests with the Gambura.
Yes,
If there's any issue that can be raised before the issue, whether it is
it agreed.
yeah, agree.
Mm.
And if decision is taken by the Gambura,
Mm.
then if the parties are agreed, that can be challenged. That can be. But in this manner, it cannot be prohibited.
It cannot be.
Prohibited.
So what do we do? No need to issue notice also.
My lord,
Or what?
From my side, Lordship, no.
Otherwise,
Yes.
notice will go.
Not required, my lord. Not
Okay.
required, because I'm not seeking title from your lordship, my lord. My
Hmm.
title will be decided.
No, not a
Competent
title,
authority.
not a title,
My-
except the order,
His
because
order.
order prohibiting.
Yes. So what
Hmm.
I pray is, my lord, your
Hmm.
lordship may kindly quash it, my lord, and giving the directly this,
Now, whether the presence of the respondent is necessary?
it will not be necessary, my lord. It is a clear-cut case, my lord. Your lordship will see the scheme of the 2021 amendment, my lord, of the Assam Frontier Regulation, my lord. It will not be necessary, my lord, in my opinion.
Yes, senior government advocate, whether notice required or just,
So far, my part is concerned, notice
Hmm.
may not be required, Lordship, because
okay.
very clear. But since private respondents are there,
Hmm.
but in the meantime, Lordship, for the private respondent also, Lordship, still they have the forum. They would be having the forum. That's a village authority. If
But
they
then,
are agreed by any issue, Lordship, they
Hmm.
can raise it before the authority. That would be the ultimate judgment that has to come from this court. That's my understanding, Lordship. Even then, I'm leaving it to this court. Because interim,
what we'll do, we'll give
interim
a
will be
short
there.
notice in the
तो
meantime.
मैं अभी के कोर्ट में को अटेंड कर रहा हूँ। जूनियर को बोलो कि उन्हीं के पास आइटम नंबर 20 पहुंचने के 3-4 आइटम पहले है।
I think it's a glitch, my lord, technical glitch.
Hmm. Let them appear if they want. Otherwise, ultimately it will go. But then let us not give chance that they have not been given an opportunity.
That I'm leaving to this court.
Okay.
Okay, my lord, then, your lordship, then kindly steady or impugn order
Mhm.
and give the liberty to this Kebang authority to proceed with the Kebang also, my lord. Legality and validity of this order will be, of course, will be decided, my lord. Legality and validity of this impugn order will be decided, my lord. My lord, the problem is actually, first she issued one restraining order. That restraining order is good, my lord. In the agreed by the restraining order, my lord, I am asserting my title there. That's why I went to the competent court. She is again putting another restraining order, my lord. Your lordship, actually we are not with record, my lord, and we cannot substantiate it. But we understand, my lord, there is some vested interest of the officer also, my lord. We understand that, and it is evident there also. People know, but we cannot prove it here with evidence. So, my lord, then it may be left open for this competent judicial authority, this BS Kebang, to go with the summon, my lord. Then summon has been issued. Summon was issued, my lord. It may be state, my lord.
If this is state, that means allowing the Gamburas to take up to proceed with the
my
matter.
lord, my lord, yes, my lord.
Otherwise, Lordship may observe, Lordship, the Gambura may proceed.
Hmm.
But that any decision will be subject
Subject to.
to the present writ.
Okay,
That can be done.
Okay, okay, madam.
what had Mr. Jamoha, learned counsel for the petitioner. Also had Mr. Tapin, learned senior government advocate for the state respondent number 1 and 2. Staff. By filing this writ petition, the petitioner challenged the legality and validity of the order dated 31/7/2026 passed by the respondent number 2, additional deputy commissioner, Mebo, whereby the respondent authority has prohibited the Aang village traditional court stroke Aang Bane Kebang from proceeding with the customary civil dispute instituted by the petitioner in respect of his claimed ancestral land situated at Yeling, Yeling, within bracket Koyo, Koyo, bracket close area. Stop. Para. It is submitted that in view of the enactment of the Civil Code, Arunachal Pradesh Civil Code Act 2020, 2021 Civil Code Act, the administrative authority no longer can exercise jurisdiction in the civil matter, civil dispute,
My lord.
Civil dispute.
However, in the instant case, due to the impugn order dated 31/7/2026 passed by the respondent number 2, the proceeding of the Keba before the Iron Village. What Keba you said? Keba of Iron Village.
Kebang of Ain, Samon,
Iron
Samon.
Village Traditional Court could not be proceeded this, although an notice has, although in person to the notice, the petitioner has appeared before the customary court, already appeared.
Customary court called, my lord. Yes, there was, but
On that, they fixed, you said that the parties appeared, you appeared. And then although Gamburas were not present, but then the
yes,
publics were present.
I appeared. Yes, my lord. I
Okay,
appeared and Gaun Buras, this prohibited by the ADC. my lord.
Okay. Staff,
But your lordship,
issue notice,
I would like to make this very clearly. I would like to make it clear
Hmm.
that decision I have annexed here on 2/8/2020, that doesn't have this judicial.
That's not a decision.
Judicial enforcement. Yes, my lord.
Which says that you only appeared
My lord.
person to the notice.
My lord.
Parwana issued by the,
Yes,
okay. The issue notice returnable by 4 weeks. Staff. Since Mr. Tapin Lanet, senior government advocate, appeared and accepted notice on behalf of the respondent number 1 and 2, no formal notice is required to be issued to the said respondent. Staff. You want extra copy?
Yes.
Okay, however, the petitioner shall furnish requisite extra copy to the National Council. Learned senior government advocate during the course of the day. Staff and the petitioner shall take steps for service of notice upon the respondent number 3, 4, and 5. Why you have impleted 3?
Impleted 3, my lord. My lord, I have impleted 3 as a pro forma, my lord, because I am going to seek this a prayer direction against him, my lord, to conduct he's the Kebang authority, my lord, only. He's the Kebang authority, my lord. So I am traditional court, Bane Kebang representative, because by name, he has been restrained, my lord, by name. Impugn order has restrained him by name, my lord. That's why. If your lordship directs me, don't find it desirable, I will delete it, my lord.
It'll be better, I think.
Okay, then I will delete.
Hmm.
I'll delete.
Okay, Mr. Jamo, Land Council for the petitioner submits that the presence of the respondent number 3 may not be required for adjudication of this case. Therefore, we press that the respondent number 3, the name of the respondent number 3 may be struck off from the course title. Start. The prayer is allowed, huh? The registration, sorry. The prayer is allowed. Okay, stop. Huh? Para. List a matter after 4 weeks. Huh? Stop. Para. In the meantime, the order dated, the operation of the order dated 31/7/2026 passed by the additional deputy commissioner Nebo within bracket respondent number 2 shall remain stayed. Start. The village council. Where is the Parwana issued?
Parwana,
What is there?
page number 58, your lordship.
Mm.
58. 58, my lord. Annex 10.
The Ayang Kebang. Is Ayang Bane Kebang?
Yes, my lord.
He is at liberty to proceed with the.
My lord, no. Ayang Banega, not Ayang Banega. It is Ayang Banega is party, my lord. Party.
Okay,
Ayang Kebang, my lord.
Ayang Kebang.
Yes, Ayang Kebang.
Ayang Kebang may proceed with the complaint case. Where do I find the case number? Complaint case of the petitioner
My lord, it is in page number this.
within bracket. Koyo among ligam pe narmi kayong parme versus Ayang Bane Kebang.
My lord.
Okay. You'll find this in page 58, huh? Within bracket, okay. However, the outcome of, however, the proceeding of the case before the KEBA shall be subject to the outcome of this writ petition. Okay?
My lord, proceeding
Proceed.
the proceeding, my lord, the
The
decision of the
decision of the KEBA, and KEBA shall be subject to the outcome of this writ petition.
okay.
Okay.
Let's give you a
Item number 4.
Yeah, my lord. My lord, this is a subsequent writ petition, my lord.
Subsequent writ
Second round of writ petition.
item.
Item 4, my lord.
Okay. Yes.
In the first round of litigation, my lord, this honorable court has passed a judgment, my lord, in our favor, my lord. That would be at page number 194, my lord. 194 is the judgment, my lord. Relevant part, I will take, my lord.
Just a minute.
Yes.
Okay.
Yes, my lord. Our background is that, my lord, since 1960, 1980, my lord, the Indian Army are in possession of our community land, my lord. So we have approached this honorable court. My lord, in page 202, my lord, the relevant part, my lord.
Yes.
Page 202, my lord.
Hmm.
Paragraph 9, my lord.
Hmm.
19, 11 is the relevant paragraph. This honorable court has passed the judgment, my lord. Hearing the submissions made by the learned counsel for both sides and after perusal of the case records and affidavits filed by the respondent side, it is found that admittedly the Indian Army had acquired the land of the petitioners, though till date there is no formal acquisition of the land, and petitioners are not provided with any compensation for the acquisition of land by the Indian Army. At the same time, it is admitted by the Indian Army, respond number 10, 11, and 12, that they are ready and willing to acquire the land of the petitioner which are in occupation of the Indian Army. Para 10, my lord. Considering all the aspects of the case and the submissions made by the learned counsel for both the sides, this writ petition is disposed of in the admission stage with the direction to the Deputy Commissioner to initiate the formal process of acquisition of land, subject to receiving in principle approval of the Ministry of Defence. And in that regard, the Defence Estate Officer, Indian Army Authority, will also send the requisition letter for obtaining in principle approval from Ministry of Defence. So this was the requirement, my lord, by the Defence Estate Officer. Para 11, my lord. After observing all necessary formalities, the Deputy Commissioner may take initiative for acquisition of land of the petitioner formally and to provide adequate compensation as per the right to fair compensation.
So what more you want?
So, my lord, what happened, my lord? The joint survey was done, page 204, my lord. Thereafter, joint survey was done, my lord. And even, my lord, this page 200, there was a completion certificate also issued by the Deputy Commissioner, my lord. Survey completion certificate. Now, what happened, my lord? Everything was done by the district administration. But the DEO, my lord, as per the direction, my lord, DEO was to take, my lord, in principle approval from the Ministry of Defence, my lord. They have not taken. Why? Because the forest, NOC, there was no forest NOC from forest department. My lord. Now my case is that, my lord, even forest, my lord, and there is no requirement of NOC from forest department. Page 211, my lord. There has been some amendment of Forest Conservation
Will
Act.
file any contempt then?
My lord, on their promise, we have not filed contempt, my lord. Now 1 year has left, my lord. The limitation has expired, my lord. Page 211, my lord. This is on the top, my lord. Any act further to the amendment, the Forest Conservation Act 1981.
211,
my lord. As per this act, amendment act, my lord. The land from LAC to 100 kilometer, my lord, they are not considered as forest, my lord.
Which section?
212, my lord, page 212. 1A, then, my lord, please come to subsection 2, my lord. The following categories of land shall not be covered under the provision of this act, my lord. Namely, my lord, now C, my lord. Such forest land, C1, my lord. 2C1, as is situated within the distance of 100 kilometers along international borders of line of control or line of actual control. My lord, we come in the line of actual control, LAC, my lord.
as the case may be, proposed to be used for construction of linear project of national importance and concerning national security. Now, my lord, my acquisition of my land comes to national security, my lord. Because the land is situated within the 100 kilometers of LHC, my lord.
Okay.
So these lands are not considered as forest, my lord.
So that is not required.
No requirement of forest clearance, my lord.
Hmm.
Despite that, they have not processed the process for in principle approval from the Ministry of Defense, my lord.
And where is the reminder?
That is
Have
our
you any-
statement, my lord. But our representation, my lord, at page 213, my lord.
Okay.
We have written to DO, my lord, and the forest and the deputy commissioner, my lord. Only for the want of NOC from forest department, my lord. They have not processed, my lord. So my prayer is only for the direction upon the respondent authorities, my lord, to process the, my lord, process for in principle approval without insisting on NOC from forest department. Because as per the act, my lord, there is no requirement of NOC from forest department.
Have you pleaded the forest department?
Yes,
also?
my lord.
Let them say
Yes,
it's
sir.
not required.
Notice.
Okay, will issue notice?
Yes, sure.
Okay. Hard, Mr. B picture, Binter picture. Planning counsel for the petitioner. Also had Mr. Lawyer for,
127, Union.
okay. Lawyer. Are you also standing counsel?
CGC.
Okay, standing, okay, CGC. Land is CGC, huh? For the respondent number
127.
127. And Mr. Reram for respondent number
8 to 16 units.
8 to Land Government Advocate for respondent number 8 to 16. Okay, stop. The petitioner is aggrieved by the alleged failure of the respondent authority, more particularly
Respondent number, my lord. DEO, my lord. DEO test.
is respondent number,
He is, my lord, respondent number 7.
more particular respondent number 7.
Yes.
To take a step person to the judgment where is the an order dated 6/11/2024 passed by this court in WPC 3/1/2023. Whereby the respondent
In paragraph,
was directed 11
yes, ma'am. Paragraph
to initiate directed to take initiative for acquisition of land of the petitioners.
in principle approval.
Hmm?
They have to take in principle approval.
IPA.
IPA from Ministry of Defense, ma'am.
Okay. Then it is a para 10.
Yes, in para 10, yes, of the judgment, ma'am. Page 202, my lord.
Mhm. to take initiate to initiate the formal process for acquisition of land subject to receiving in principle approval
Yes, in principle approve.
of the Ministry of Defense. This is particularly to the respondent number 7.
Yes, my lord.
And further directed the State Defense Officer stroke Indian Army Authority to send the requisition letter for obtaining in principle approval from Ministry of Defense. And also directing the Deputy Commissioner to take initiative for Deputy, the Commissioner probably has already taken a step.
Yes, he has done his part.
Okay, to take initiative for acquisition of land of the petitioner formally and to provide adequate compensation as per the right of fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. So, however,
Yes.
despite of above direction, the acquisition process has otherwise
Yes,
initiated.
yes, hold,
The acquisition-
hold it, yes.
Although the acquisition proceeding has been initiated by the Deputy Commissioner, but the respondent is insisting for the
Yes, ma'am, forest clearance.
forest clearance, which
NOC
According
from
to-
forest.
insisting for NOC from the Forest Department,
Yes.
which according to the Land Council for a petitioner is not required,
Not-
not necessary
Yes,
in view of the provision under
the Forest Conservation under bracket Amendment Act 2023. Page 211.
1A,
Yes, ma'am, 1A,
within bracket 2, within bracket C, within bracket I
yes,
of the within bracket conservation, bracket close Amendment Act 2013,
23, ma'am, 2020.
sorry, 2023.
Yes.
Staff of that. Issue notice. Since Mr. Lawyer appeared and accepted notice on behalf of the respondent number 1 to 7 and Mr. Ram for state respondent number 8 to 16, no formal notice. And the notice stand waived. Stop. However, the petitioner shall furnish requisite extra copies to the Land Council appearing on behalf of the respondent within 3 days from today. Staff and list the matter after 4 weeks.
Madam, any date after 4 weeks, ma'am. Any date after 4 weeks. Or a specific date may be given, madam.
Specific that.
Yes, ma'am.
Hmm.
Any date after 4 weeks, ma'am.
Why it will automatically come?
No, my lord. It is when the date is given, my lord, they initiate their action. ma'am.
In that case, the 5th of October.
5th of October. Okay. 5 October. Hmm.
All right.
Item number 5,
Obliged.
My lord,
Yes.
my lord, just before indulging my lord to the
Mhm.
lectures,
Mhm.
just give, I'll give a brief background of this case. This petitioner, MS Electropoles Products Private Limited, is an ISO, my lord, BIS certified manufacturing, supply steel tabular poles, STP poles for various central and state power distribution systems across India since 1985. That means, my lord, more than over 40 years, this company is in this business, my lord. So, considering their credential and credibility, then there is a scheme called, my lord, the Revamped Distribution Sector Scheme, RDSS in Arunachal Pradesh. The petitioner supplied 9 meters STP poles that is 410 SP dash 32 grade as an approved sub vendor for the three packages, my lord. Kurung Kume, that is 283 numbers. Changlang, my lord, 397 numbers. And Londing, 340 numbers. Now, my lord, what happens is,
The cake kurung ke mein,
Kurung Kume, my lord, Kurung
Changlang.
is Kurung Kume, Changlang, and Londing, my lord.
Okay, long, 3 districts.
3 districts, my lord. Now, what is the mode of delivery, my lord, of these polls? There is a PDI, pre-delivery inspection, my lord, in terms of the agreement, my lord. So the representative officer of the state respondent one and the petitioners must do the joint pre-delivery inspection, my lord. So this has been done, my lord. Then what had happened is, my lord, the joint PDIs were conducted by respondent number 1 officers and petitioners between 9/8/2024 and 22/8/2024. That is called NBAL test type test certificate recorded tensile strengths between 472 and 478 MPa, my lord, comfortably exceeding the statutory threshold of 410 MPa. That is the requirement, my lord, under IS 2713. So now what had happened was, my lord, the respondent number 1 subsequently, my lord, issued material dispatch clearance certificate, my lord. That dispatch instruction certifying the material as satisfactory, my lord, will kindly see, my lord, page 35, the annexure 1. These are the case report.
Page 35.
Yes, page 35. That is by dated, yes, CS2, no, 6, right?
6/12.
Yes. So this is the one that we have sent, my lord, till 45. We have done it, my lord, up to page 45. And there is no dispute on this, my lord. Pre-dispatch inspection record, test type certificates, and dispatch instructions is contains from page 35 to 45. Now, my lord, what had happened was there was a small issue. Then no advance intimation was ever issued to the petitioner on turnkey contractors to witness either round of site sample testing conducted by TPQMA, my lord. And my lord, this is, my lord will see at what is this TPQMA, my lord, technical term I cannot mention, also being a non-technical person, my lord. Inspection report confirms that notice were sent only to the respondent number 1, my lord.
Third party quality monitoring agency.
Yes. Third party. Further, the turnkey contractor MS Industrial System LLP.
It's a turnkey contract.
Yes, no, turnkey contract. So, confirmed in writing dated 22/3/2025 that no advance notice was provided. My lord will have page 56, my lord.
Yes.
Page 56 is there. Okay. These are the things, my lord. Now, having done this, my lord, in between what had happened was there was a delay for 75 to 150 days, my lord, by the respondent number 1 itself, my lord. My lord, kindly see that annexure 2, my lord, will kindly flip back.
Page
43. 45, sorry, my lord. That is called this mandatory quality guidelines, my lord. What is the field governing is that field material quality testing and inspection, FMQI, is strictly governed by the guidelines for quality monitoring, my lord, by nodal agency through TPQMA issued by the Power Finance Corporation, FC on so and so that. Well, what is this? These, my lord, will find that page 48. My lord. Page 48 is important for us. I'll assist their lordship to this aspect. There are 3 important clauses, my lord. The first is 2.3, my lord. My lord will have this 2 at page 46, my lord. Role of nodal agencies, PFC, stroke REC to comply with quality assessment monitoring, something like that. The important clause involving in our case is 2, my lord, 2.3. And my lord will also note 2.5. Here, my lord, may I seek the indulgence of my lord to 2.51. These 3 paras are very important for me. It says the equipment shall be sealed jointly in presence of TPQMA, representative of employer, contractor, and supplier, stroke manufacturer, if his representative is available at site. That's the first condition. 2, my lord. 2.53, my lord. The employer shall be responsible for safe handling, packing, and transportation of the sealed material up to the identified testing laboratories. All expenses relating to logistic and transport shall be reimbursed to the employer, PPQMA, as the case may be by nodal agencies. Now, main point is here, my lord, 2.56, my lord, 3. 2.56. In case where pre-dispatch and factory test results and ABL accredited to lab test report are found significantly mismatched with test results on the sample picked from field, action shall be taken against willful defaulted manufacturer and turnkey contract or both. Now, these are all the clauses, my lord. 2.5, these. My lord, kindly see, there we have made a categorical statement, having performed all these tests, my lord. Having performed all these tests, my lord, there was a deliberate delay of 74 to 150 days. The samples, my lord, were samples sealed at site on 27/12, my lord, 2024, Kurungkome, my lord. Kindly mark this date, my lord. That's all that contains in the read petition, my lord. The materials were sealed in respect of Changlang, in respect of Kurungkume was, my lord, 27/12/2024. Zero 4/01/2025 in respect of Changlang, and my lord,
04?
04/01/2024, January 2025. Then 13th January 2025 was for Londing, my lord. And were sent for testing only on 19/3, my lord. Take out that election. On 19/3/2025 and 19/5/2025 with reports generated on 06/6/2025. Now, my lord, this delay of 74 to 150 days directly breaches clause 2.63, my lord. This directly breaches 2.6.3 of the PFC, my lord, that we have gone through a while ago, my lord, which mandates completion within 60 days, my lord. In 60 days period, you have to do it. My lord, have seen that from 74 to 150 days, delay has been committed by the respondent authority. My lord, for that, kindly have annexure 3, my lord.
Okay, page.
Annexure 3. 55, sir.
Yes.
This is our petitioner's testing timeline audit, my lord, that we have fulfilled, my lord. Now, again, thereafter, my lord, what had happened was, there was improper handling and testing at competitive premises. Now, here we apprehend the bias, my lord. Because, my lord, in breach of, my lord, 2.5.3, there is an obligation that the employer ensures safe transit. Samples were transported on non-flatbed vehicles over rough terrain, severely damaging structural integrity. Now, they are supposed to ensure the safe transit of the materials. once it is dispatched by us after fulfilling all the tests, my lord. Now, what had happened is another important point my lord would note. The second round testing, my lord, was conducted at the premises of MS NTL Steel, a direct commercial competitor of the petitioner, my lord. That is the reason why we have this biasness, my lord, of the petitioner without petitioner's knowledge or our consent, my lord, giving rise to a reasonable apprehension of bias, my lord. This is what we are apprehending, my lord. Now, what had happened is there is the test result thereafter across identical segments of same pole sword, my lord, biologically stroke physically impossible variating, that is bottom 358-336 MPa versus top 50 MPa, providing float copper extraction taken near the wheel rather than the structural manufacturing of defects, my lord. Now, my lord, this, what had happened thereafter, they have served as the show-cause notice. Then, my lord, what happened? Following the initial rejections of our following the initial material rejection certificate dated 6, my lord, 6/2025, my lord, annexure 5, page 65, my lord.
This is,
There was a rejection letter from them, and then we have replaced all three, my lord, lots at its own cost and causing zero, my lord, financial loss to the utility, my lord. Now thereafter, my lord, after that, my lord, what had happened is kindly have page 75, my lord.
so where is the testing report?
That is, my lord, page 65, annexure 5.
Where do we find the relevant portion of the report?
/65 or 66, my lord. So certain technical things, you know, Hindi and English are mixed. So 69, lord. /68 and 69.
Is the report, yes.
I think Hindi is another problem here. Figure 3, lord. Electro Products Private Limited द्वारा डिपार्टमेंट ऑफ पावर गवर्नमेंट ऑफ अरुणाचल प्रदेश को लोनिंग जिले में लॉट नंबर अरुण सो एंड सो के तहत आपूर्ति की गई सामग्री STPL कोल 9 mm की पूरी लॉट संख्या 340 PDI स्ट्रोक DI के अनुसार को अस्वीकार कर दे. That means reject this. So when this rejection was there, then my lord, we have of our own cost, we have replaced the whole material. That English version is down below. my lord.
Hmm.
So
In
that,
Longding district,
Yes.
where is supply material lying in sites in transit,
yes.
testing and commission has already been commissioned. Quality department of the action.
Now, my lord, these
And also ensure that the above mentioned things does not supply the rejected material again.
correct. Now, my lord, this issue had been raised to last by speaking order dated 22/1/2026.
It's a willful default, it says.
But this entire issue, my lord,
Hmm.
has been laid to rest by a speaking order by the respondent themselves.
Hmm.
My lord will have annexure 8, my lord, page 75. Just take out page 7. Because they wanted to debar us. And then by this letter, my lord, they have deferred our debarment as one-time measure. Number 2, we were placed under 12 months of strict provision with 100% field sampling.
Hmm.
Then 3, my lord, explicitly holding that department for 5 years would follow only in the event of any further failure during this 12-month period. My lord, in this 12-month period, my lord, we have committed no breach or committed any fault in supply of the materials, my lord. Now then, what had happened, my lord? Thereafter, my lord, kindly come to page 81, annexure 9, my lord. Now the respondent, they, without any subsequent default or test failure, my lord, during the probation period, the respondent number 1 issued a second show cause notice on 27/4/2026, my lord. That, my lord, will find it annexure 9, my lord,
During this period.
during this period.
Okay.
There was no fault, nothing, my lord, as seen now.
Hmm.
My lord, let us read together.
Hmm.
It's 2 pages only.
Hmm.
Whereas 9-meter tabular poles manufactured by MS Electro Poles Product Private Limited have failed in 3 RDS packages in Arunachal Pradesh, namely Kurungkume, Londing package and Changlang during field material quality inspection and testing at NBL accredited laboratory in both first and second sealing and sampling testing. Whereas REC had issued material rejection certificate, white letter number so and so, for 9 meters steel tabular poles in respect of Kurungkume package, Londing package, and Changlang package. Whereas during review meeting held at Tawan, the executive director, RAC PMD, had categorically instructed the Department of Power, Arunachal Pradesh, to initiate necessary action against the manufacturing and turnkey contractor as the provision of the SBD. Whereas the show cause notice, my lord, was issued to MS Electro Poles Private Limited, white order number so and so, dated 22/12/2025, as to why actions should not be taken against the manufacturer. Whereas replying to, my lord, we have replied this on 22, my lord, 22/1/2026, which they have quoted, stating that as one-time measure, SBD Part 2, employer's requirement 4.1.6 shall not be invoked upon the manufacturer. My lord, that is the binding clause, in which they acknowledge as, my lord. Now, thereafter, my lord, the operating portion is at page 82, my lord will see. In view of above, MS Electro Poles Product Private Limited is hereby called upon to show us within 15 days of issue of this letter as to why. Is speaking order number. May not kindly mark this, that earlier we have referred to this order dated annexure 8, my lord, will recall annexure 8, my lord, page 75. They have already deferred debarment as one-time measures, my lord.
This is during pendency of that.
Dependency of that,
Hmm.
my lord. And then, my lord, and during this period, my lord, would not.
It's almost immediately.
Yes.
This was in January.
This was in
Hmm.
January, and we have finished it, my lord.
Hmm.
So therefore, my lord, this the unlawful, I term it as an unlawful second show cause notice, my lord. Without any subsequent default or test failure, my lord, during the probation period, respondent number 1 have issued this show cause notice, so and so, my lord, agitating identical, my lord, set of facts closed by the speaking order. All issues were raised to laid by this order itself, my lord. Now, my lord, kindly see, the problem is here, this impugn order, my lord. Annexure 10, page 86, my lord. It is completely a non-speaking and unreasoned impugn debarment order, my lord.
The impugn order is 87
Yes, no, 86,
order.
page 86.
86 or 87?
It-
Order. Order
87.
87.
order.
3/6/26.
87, yes.
87.
Kindly see. Before that, my lord, kindly come to page 83. This is we have filed a comprehensive technical reply to their show cause notice, my lord. And we have given all sorts of justification to them. that during this period, we have performed our duty with due diligence and nothing less, nothing more on that, my lord. So they have written to us confirming so and so, my lord. We have given this to them, my lord. Now thereafter, even after clear justification, my lord, these impugn order was passed at Annexure 11, page 87.
Okay.
But this
So-
order, my lord, kindly see, there is no application of mine at all while passing this impugn order, my lord. This cannot be. It cannot be order simplicity, delivering somebody. My lord, kindly see, is only 4 paragraph. My lord, first, second, I will not read. Third paragraph, my lord. Whereas the second so-cast notice was issued to MS Electro-Poles Product Private Limited, wide order number so and so as to why action should not be taken against a manufacturer. My lord. In view of above speaking order, so and so dated 22/02/2026. My lord, kindly flip back to page 75. Because all the dispute between the parties were raised by this order, my lord, 22 January 2026 order, my lord. They have deferred the debarment as one-time measure, my lord. Secondly, we were put on 12 months of strict quality prohibition with 100% field sampling, my lord. Then explicitly, my lord, holding that debarment for 5 years would follow only in the event of any further failure during this 12-month period, which, my lord, we have
So earlier it was 12 months. Now it is for the period of 5 years.
5 years. Now,
Okay, that was cancelled 22/1,
Yes.
2026.
all the dispute that had arisen earlier time was raised to late by this order itself, my lord. And thereafter, there is no default from our end, my lord. Nothing, my lord. And, my lord, kindly appreciate this. Without any subsequent default or test failure during probation period, now respondent number started acting this, my lord. Now this impugn order is the consequences of this, my lord. And, my lord, will also note, my lord, in this impugn order, my lord, my lord, will notice is devouring the petitioner for 5 years across all power utilities, my lord.
No, in Arunachal Pradesh only.
Yes. And then we are,
No, not for other state.
yes, my lord. Still then, my lord, we will be affected because we are doing business in 7 to 8 states across the
No,
country, my lord.
it's not for other state. That is
Yes.
what I'm saying.
No, correct, my lord. But it will have a bearing, my lord. Normally, once the farm is blacklisted in this manner and devoured for the 5 years period, my lord, then
Now see the replay your,
then, my lord, kindly see, we have submitted a representation, my lord.
you said that you have replaced
Yes, we replaced
the
everything.
quality which was rejected.
Earlier, which was rejected, we
So
replaced
that shows,
at our own cost, and there was no quarrel after 22/1/2026.
that shows the quality that which you have delivered
Yeah,
in the
initially, my lord. So then that's why I said all issue that arose at earlier occasions of defect in the quality, that was settled by us. We replaced everything. And it was,
So that is why I'm saying
Yes.
you have replaced because it was substandard,
yes, sir.
the quality, okay?
So,
And this shows the conduct. They are very difficult for the state.
well, my lord, I appreciate that. There must be a concern.
Anyway, so
So, my lord, kindly see, I am praying for interim order, my lord. On the similar,
let us
well, just I am placing a small 2-3 citations. Just on the, I will not read
Sure.
out the paragraph. I will quote and place it, my lord. On a similarly situated case, my lord, it is by the West Bengal High Court, which has paused and set aside this debarment, my lord. Thus, I am placing it, my lord. They give me extra hours. I'll promise to go out. But this is a small judgment we can read together.
Hmm.
The petitioner, fact is, my lord, the petitioner has filed the present writ application challenging the impugn order dated 8 May 2026, wherein the respondent number 2 has passed an order by discontinuing the firm in all power utilities of the country for a period of 5 years, including in power utility concern, where this act is found by the said order. The respondent number 2 has debarred the petitioner from supplying material for next 5 years. To
This is for all utilities of the country.
country.
Hmm.
So it will be applicable for Arunachal only. That's the main grievances of the petitioner by challenging the impugn order is neither any so-called notice was issued to the
This is different.
and this was not done to us, my lord.
So
there-
notice was given
yes,
here.
yes.
There is a so-called notice.
There is so-called notice,
Hmm.
but then our representation, what we have submitted,
Hmm.
has not yet been addressed yet. So, my lord, therefore, on this basis, on the same fact, my lord, the Calcutta High Court has passed and set aside the debarment order.
I think this is different
No,
because here so-called notice was issued. But
Yes.
in our case, in the present case, so-called notice was issued.
there was.
Anyway, let us, well,
I'll not read out the paragraph.
okay.
I'll tell the proposal.
Hmm.
My lord, my lord, on the proposition, my lord,
Hmm.
blacklisting debarment causes civil debt to the commercial entity. A so-called notice proposing debarment must be unambiguous and explicitly state the exact penalty proposed. Here, this has not been proposed, my lord. So, administrative orders passed without adhering to strict natural justice safeguards are void ab initio. My lord, this is UMC Technologies Private Limited, my lord. The citation is, what is the citation? My lord, paragraph 13, 14, 15, 19, 21, and 25. Go ahead. You take out all the citations. My lord, the paragraph 13 to 15, 19, 21, and 25. My lord, on the proposition that blacklisting debarment causes civil debt to a commercial entity, a so-called notice proposing debarment must be unambiguous and explicitly state the exact penalty proposed. Administrative orders passed without adhering to strict natural justice safeguards are void ab initio. So these on this proposition. The second proposition, my lord, I am relying this Gorkha Security Service versus Government of NCT. Of course, this citation I have not given them to. My lord, this proposition, kindly take down this.
At this stage,
Yes.
probably this may also not be required. We'll issue notice.
My lord, kindly till that returnable date.
See, they all already.
We are well within the time filing.
Hmm. It was issued on 3/6.
Because, my lord, what I believe is,
3/6.
my lord,
And in the state of Arunachal Pradesh, probably except for these three districts,
yes,
where other, in which district?
we don't know. We are
And
concerned.
then,
No. My lord, we are allotted to these three districts of
Hmm.
Kurung Kume, Changlang, and Londing. The issue is relating to the three districts.
mhm.
So, my lord, kindly see that what I would respectfully submit before my lord is that
Hmm.
the punishment is disproportionate.
5 years.
The 5 year is disproportionate because at the end, my
Had
lord,
it been the individual, it would have been more.
well, fine, my lord. What the law says, my lord, that Kulja Industries, my lord, I am relying
Because,
this.
because if it's not a crime, not an offense, of course, criminal. But then had it been the criminal offense, then offense has already been committed.
I agree, my lord.
Hmm.
I will have to bow down what
Hmm.
calling from their lordship.
Hmm.
Lordship will also appreciate the prejudice and predetermined cost to me.
That
So
will
therefore-
consider, that will consider in the
My lord,
meantime.
kindly see
Hmm.
this Kulja Pulja Industries Limited. This judgment I'll close up.
Which one?
2014, my lord.
Okay,
2014.
the earlier one.
No, another one. This is the last one I am relying.
Okay.
I have this. The fine. Pulja Industries. This is the only citation I will conclude. Then I'll pray for the
The paragraph?
paragraph 17, Lord, and this. Well, my lord, we'll see, because here the fair hearing was not given to us in this case. You have a power, absolute power to pass any kind of order, but you must afford an opportunity of fair hearing to us. The same on the contract basis, my lord. Fourth line, my lord. Just 2 lines about the placetum B, my lord. That is because blacklisting simply signifies a business decision by which the party affected by breach decides not to enter into any contractual relationship with the party committing the breach. Between 2 parties, the right to take any such.
Wait, where are we?
Placetum, my lord. Placetum.
Para 17.
17, Lord. Placetum up just after placetum B. My lord can have this after line 4, 5. Of the line 5.
Line?
Line 5, Lord. That is because blacklisting. Yes.
The implies.
That is because blacklisting simply signifies a business decision by which the party affected by the breach decides not to enter into any contractual relationship with the party committing the breach. Between 2 private parties, the right to take any such decision is absolute and untrammeled by any constraints whatsoever. The freedom to contract or not to contract is unqualified in a case of private parties, but any such decision is subject to judicial review when the same is taken by the state or any of its instrumentalities. This implies that any such decision will be open to scrutiny not only on the touchstone of the principle of natural justice, but also on the doctrine of proportionality. A fair hearing to the party being blacklisted thus becomes an essential precondition for a proper exercise of power.
Stage has not yet come here in this case.
No, here what had happened, we were not afforded opportunity of being heard. One. And then we have our representation is pending and that is yet to be, that remains unanswered.
Okay.
So therefore, my lord, this is, then all those, my lord, this Pulja paragraph 20, 25, 26, if my lord see, then my lord will appreciate this. So therefore, my lord, my respectful submission is to, in hiatus, kindly provide some relief by staying this impugn blacklisting order. That's my argument for this.
Okay. Yes, Anik.
Well, I am for respondent number 1 and 2, my lord.
Okay.
Now, my lord, before placing my argument, my lord, this whole scheme, my lord, is RDDS, my lord. Now, my lord, in RDDS, my lord, this is a centrally sponsored scheme.
Respondent number 5.
I am for 1 and 2, my lord.
You are for 1 and 2?
1 and 2, my lord. This RDDS, my lord, is centrally sponsored scheme, my lord. The nodal agency, my lord, of this scheme is respondent number 3, my lord. It is RE Limited, my lord. We are, my lord, state nodal agency, my lord. Now, this scheme, my lord, is a very comprehensive scheme, my lord. All the things are in place, my lord. How to make payment, my lord. How the tender is to be called, my lord. And how the agreement is to be drawn, my lord. How it will be implemented. This is well comprehensive scheme, my lord. Now, my lord, at heart, my lord, this petitioner, my lord, is in this business since 1985, my lord. Oh, 1985, my lord. Then, my lord, surely, my lord, he know, my lord, what is the consequence. As this is comprehensive scheme, my lord, there is all the thing, my lord, all the agreement, all the mode of implementation is in place, my lord. Therefore, my lord will kindly turn to page number 4. 49, my lord. 49, my lord. 49, my lord. Now, when I submit, my lord, this is comprehensive scheme, my lord. There is a already, my lord, a guideline is there, my lord, how all the material should be quantity of the material, my quality, my lord. All the comprehensive guideline is there, my lord. Now, if, my lord, suppose any default, my lord, what is the consequence? That also is placed, my lord. That is in page 49, my lord. 25611, my lord. 25611, my lord. Sub vendor
256.
25611, my lord.
Okay.
Sub vendor registration of the manufacturer be discontinue all the power utility of the country for the period of 5 years, including a power utility concern where this act is found, my lord. Whenever, my lord, this any mismanagement, my lord, is happened, my lord, that it is written, my lord, this that will be bar of 5 years, man. That is the written condition, and under this written condition, he made a supply, my lord. Now, my undisputedly, in this case, my lord,
In all power utilities, discontinue
my lord, for 5 years, my lord. This is a written condition, my lord.
of the country.
Now, undisputedly, my lord, not only not in only in one district, my lord, as much as 3 districts, my lord.
So action is.
Action is written, my lord. What will be consequence, my lord? That is known to him, my lord.
Okay.
Now, undisputedly in this case, my lord, not in one district, my lord, in all 3 districts, my lord, not for one time, my lord, there is a second testing also, my lord. On second means, my lord, as much as 6 tests, my lord, his material failed, my lord. Now, the consequence is written, my lord. Ultimately, we need to go by this is in terms of the contract also, my lord. The consequence he has to pay, my lord. And what happened in this case, my lord? The nodal agency with this speaking order passed, my lord, was there speaking order, my lord, by the, yes, we consider that, my lord, that was the authority, my lord, overlooking this provision, my lord, has passed that order, my lord. Then, my lord, review in the review meeting, my lord, that was point out, my lord, accordingly, my lord, the action, my lord, in terms of the retained contract was passed, my lord. Now, that was known to him, my lord. Therefore, my lord, the citation, my lord, rely by the he is not relevant in this case, my lord. That is a case, my lord, when there is no contract, my lord, the action is taken, my lord, then surely, my lord, there is necessary national justice. Here is there is a written contract, my lord. In case of default, the consequence be this, my lord. Now, that is known to them, and he default not only in one, my lord, in 3 in I say in 3 districts, ever his material was supplied, my lord. In whole district, he failed, my lord. So this consequence follow, my lord. Therefore, here in this case, my lord, there is no case of consequence of national justice, my lord. Therefore, my humble submission, my lord, if any order, my lord, if this interim order is passed, my lord, that will amount to allowing his writ petition, my lord, and that will be against the public interest, my lord. Now, this scheme, I say, is very comprehensive, my lord, especially for the benefit of the public, my lord. So, looking into taking into balance, my lord, of the public interest, my lord, not pass any interim order, my lord. Other aspect, my lord, I will detail reply, my lord. In one submission, my lord, he is alleging some bias toward the third party monitoring committee, my lord. That is also part of this guideline also, my lord. Now, he is not made a party, my lord, not that in the such submission, my lord.
Part of? That is also part of?
Part of a deep comprehensive guideline, my lord. The third party monitoring.
The third party is there, but then he says it's
third party monitoring. He is saying that
Competitor-
it's some
competitor.
competitor, but he is not made a
Competitor.
party to this third party, my lord, in this petition, my lord.
okay.
In absence, he being a part party, my lord, such
Yeah.
submission cannot be made, my lord.
Well, issue notice.
Notice maybe, my lord.
My lord, only request,
Hmm.
because our representation, detailed representation,
Let them file affidavit.
no, my lord, that will really prejudice.
Hmm.
My lord, may give me a short at 2 weeks' time.
Hmm.
And at the end of the day,
Hmm.
this case ultimately have to remand back to the authorities to take a fresh decision.
Hmm.
till such time, you know, because material, there is no dispute on the materials. Everything is delivered from our side.
Yes, the
Even
dispute is only with regards to the quality.
Quality, only 22, my lord, because this 74 and 150 days delay was caused by them, not from our end, my lord. That I have categorically made a statement.
No, let them explain why delay and what.
Only for 2 weeks,
Hmm.
kindly. Only for 2 weeks, my lord, till that.
Okay, hard, Mr. Yes, lawyer, you have anything? We can, correspondent number four. And then who appears for three?
It will be no, my lord, a private respondent.
Private respondent.
Private respondent.
Okay,
Now, he is the nodal
Okay.
agency, my lord.
okay,
So his absence also, my lord, the
okay.
interim order, my lord. I pray, my lord.
Okay,
that
hard,
will not
Mr.
be-
D. Tara, Lana Senior Counsel, assisted by Miss Lana Counsel for the petitioner.
My lord, there are 2 other colleagues from Delhi. They
Okay.
gives me, I have given their name, my lord.
Okay.
Before their names.
Okay, namely,
Me.
assisted by Miss. And okay, yes, your question, Lana Counsel for the petitioner. Staff also heard Mr. L. Perme. Listen, Perme, Lana Counsel, Lana is
Standing council matter,
standing counsel for
power department.
the power department for respondent number 1 and 2, and Mr. Lawyer for respondent number 4. Stop, huh? The para, huh? By filing this writ petition, the petitioner has challenged the impugn order dated 3/6/2026, whereby the the respondent number, this was issued by respondent number 1,
2, my lord.
respondent number 2 has passed an order is a cancel.
No cancellation. Only we have been debarred. Had there been a cancellation?
Debarred from supplying
Supplying, yes.
material to the Department of Power, Government of Arunachal Pradesh for a period of 5 years. Stop, huh? Para. Will issue notice straight away. Issue notice. Since issue notice returnable by 4 weeks. Stop, huh? Since Mr. L. Parme and counsel appear on behalf of the respondent number 1 and 2 and Mr. Roy for respondent number 4, no formal notice is required to be issued to the said respondent. Staff. However, the petitioner shall furnish requisite extra copy to the Land Council appearing on behalf of the respondents within 3 days from today. Staff. The petitioner shall take steps for service of notice upon respondent number 3. Staff. 3 by a speed post as well as by user process within 4 days from today. Staff. Para. List a matter after 4 weeks. Staff. Para. Having regards to the nature of allegations and the fact that impugn order dated 3/6/2026. Then impugn action by passing the order dated 3/6/2026 relates to prevention of further supply of material whose quality has been found to have failed the prescribed quality testing. Twice, or no, will not mention, comma, no interim stay of impugn order is granted at this stage. Stop. However, the interim prayer of the petitioner shall be considered after receipt of the response from the respondent. The respondents shall file their response within 2 weeks.
So, my lord, the 2 week base, oh, my lord, my lord, no, my lord, it need to be go to the law betting, my lord. I pray 3 week, my lord.
3 weeks.
And in the meantime, my lord, the service to the
And
respondent
advance
is
copy to
necessary, my
the
lord.
counsel for the petitioner. So, huh?
Service to the respondent notary will be necessary, my lord, as he is
Yes.
the main nodal agency.
Direct case within 4 days. Okay.
But my lord, in the interest of justice, kindly protect us, because it is not a. it
No, my
is
lord,
not a point-
So
This
this
is a intentional, my
supply
lord.
of the
My
material,
lord, it's
supply of the material,
my lord.
and then the found you fail in testing. It's very difficult.
Fine, my lord.
And the concern of the state, it's not, of course, but then the laws provide itself,
Yes, my lord.
read out clearly. There's a provision. You have,
My lord, kindly see,
and
we were not given a personal hearing and our.
but then that will consider, because it is for 5 years. In any case, it was initially you were also agreed upon
Yes, my
that
lord.
12 months. But then in the meantime, within 3 months, of course, this has been issued. That will consider after examination, final order, it will not affect, because the restriction I have seen, the as per the provision, it is entire country. But then here is the case where only Arunachal Pradesh.
There were
You are in the,
no lapses on our part,
hmm,
and the so-called notice was issued that way,
hmm.
and we have not supplied. And all the materials were supplied earlier only, on the basis of that which was already settled by order dated 22/01/2025.
Hmm.
Then you cannot penalize me for twice.
Yes, we'll examine that one, that your allegation also, that your rivalry, the test was done through your rivalry.
Ha.
Competent, competitor. So that also they will have to answer. Let us see.
But that third part is not a part in this case, my lord.
But that
So
is
they may have to probably
probably
plead.
we'll take
Ah.
care of this.
Okay,
Alright.
we'll take a break of 5 minutes.
Yeah.
Obvious, my lord.
Yes.
Item number 9.
Pleasure, Your Lordship.
Hmm.
Item nine, well, respondent number, private respondent, they have filed counter affidavit.
Ready for hearing?
I may be given some time to file rejoinder.
Rejoinder.
Yes.
Okay.
Maybe 2 weeks, we will file a rejoinder to the respondents.
Okay. So the affidavit filed by whom?
Filed by respondent number 4,
4.
and then by the state also. That
Okay.
is
So all.
2, yes,
Okay.
all.
Mr. S. Mo. Who is for the respondent? Yeah, okay.
Yes, 1, 2, 3.
Son Mo. Lani counsel for the petition. Also had Ms. Sir, Lani government advocate for the state respondent. Neris is there?
No, this is not related to Naris.
Okay.
Private respondent.
Item 9.
For item number respondent 4,
Okay.
Ajin Sar is appearing.
Okay. Also had Mr. Ajanapang, Lani's senior counsel, appearing on behalf of respondent. Respondent number 4. Staff. So they want to file a rejoinder, seeking time. We are allowing.
Yeah, okay.
Okay. How much time you said?
At least 2 weeks, my lord.
Okay, Mr. The learning counsel for the petitioner submitted, as he has received the affidavit in opposition filed by the respondent, he may be permitted to file affidavit in reply, for which he prays for 3 weeks' time. 3 weeks.
2 weeks, my lord.
2 weeks' time. Stop the prayer having not been objected to. The prayers are made by the counsel. Learning counsel for the petitioner has not been objected to by the learning counsel appearing on behalf of the respondent. Accordingly, the prayer is allowed. List a matter after 2 weeks. Okay.
Problem.
Good to see.
Item number 10 and 11.
My lord,
So
item number
far as,
10.
my lord, so far as item number 11 is concerned, I am appealing for the respondent NHPC, and we have already filed our affidavit in opposition in the month of February 2026. Now, my lord, so far as item number 10 is concerned, I don't know, because we have not even entered appearance in this case, but I have been given to understand that the file shows non-compliance of service. So I am not appearing in item number 10. We have no instruction to appear as on date.
My lord,
But 11,
we have,
Whether in item 10, no affidavit has been filed,
Yeah.
I think, so
No.
far.
we have taken steps of through Dusty and again by registered post on 24/11/2025.
Whether they have received.
My lord, we have taken steps through the registry.
No, you said Dusty.
The Dusty, I have the
After Dusty service, have you filed any affidavit,
No.
compliance affidavit?
No.
No, not yet.
not yet.
Then in that case, you have to file compliance affidavit.
And then secondly, again on 24/11/2025,
Mhm.
when registered steps were taken through the registry, and
Not
so
returned.
far we may treat it as deemed.
Not yet, not yet.
or I may do one thing,
State
my lord.
respondent has not, state respondent has also not yet filed.
No,
Not yet.
Item 10.
we also have to file, Your Worship. We need some time, Your Worship. 3 weeks, Your
This is
Lordship.
approach here.
My lord,
Okay.
if my esteemed friend, Mr. Burton, because that's not really formal, but if a copy of item number 10, copy of the writ petition in item number 10 is handed over to Mr. Inchin by Mr. Burton, I will instruct him to accept it and I will inform the NHPC. And that may be
So handed over to
compliance.
whom? Handed over to
Mr.
whom?
Mr. Rinchin Dido. Rinchin.
Okay.
Anil
Who
Thungan.
is,
That may be recorded. I will do that.
Oh, yes, please.
where is Rinchin?
Mr. He may not be present. May not
Okay.
Anil
He's not
Thungan.
here now, but I
Mr.
will serve
Patil
the
knows.
copy.
Okay.
He was also the junior of Mr. Tony Patil. So, junior turned senior.
Then,
So, there's no difficulty. So, my lord,
Okay.
let it be handed over then
the-
only, otherwise there will be a
Rinchin will
problem.
accept on behalf of,
My lord,
Four
you
and
will
five.
receive-
In
4 and
item
5.
in item number 10 also 4 and
my
5.
lord, let me make it clear. As so far as the practice is concerned in NHPC, they engage counsel on case-to-case basis. Till date,
Okay.
no engagement has come because service could not be completed. I'm helping my friend out. If he gets a copy, I will inform NHPC and then I will get the
Okay.
engagement from them.
Okay.
So
Okay. That's
I'm
fine.
following this procedure to help Mr. Patel so that service
Okay.
gets affected. So let the matter may
Already-
come after a week. Let the matter may come after a week. In the meantime, Mr. Patel will ensure that Mr. R.L. Thungan gets a copy and I will inform the court that we are entering appearance.
Okay.
And then our
Mr.
presence may be
Patil.
recorded.
Learning counsel for the petitioner.
Then next week again.
Oh, yes.
Okay. The state respondent is the respondent number?
1, 2, 3.
Okay. In item 10, Ms. Basar, non-government advocate for the respondent, state respondent number 1, 2, 3, and 1, 2, and 3. Prays for further.
3 weeks time, Lordship.
She is praying for 3 weeks' time. Then in that case, it will not be able to be listed.
No, well, let it be listed next week because Mr. Tiwari has to formally
Okay.
make
But
Okay,
my
three
lord, my
weeks, for
presence
three
may not
weeks
be
time.
recorded. my presence may not be recorded in item 10 because legally
Okay.
I can't appear for them. But I'm ensuring that to help Mr.
For a
Patel.
for a 3 weeks time to obtain instruction and to file affidavit in opposition on behalf of the state respondent staff. Huh? Then your name not recorded, then in that case, you are for respondent 4 and 5.
Yes, nobody can appear for NHPC unless and until engagement comes. But I will help Mr. Patel. Lordship may not show our presence in item 10.
Okay, in
If it
item,
doesn't accept, I will say, I will go for order
It will be.
595. Yes, but
I'm
the team from-
assuring Mr. Patel it will be accepted. I will
Okay.
instruct Mr. Tungan. It will be done. Rest
in
assured.
item number 11, 12, 13 and 14. Oh, Mr.
And 11, we have filed affidavit in
P.K.
opposition.
Tiwari, Lana Senior Counsel, Senior Advocate, Senior Counsel, appear on behalf of respondent number
NHPC,
4 and 5.
4 and 5.
Item 11, we have filed affidavit.
4 and 5.
I have also filed my rejoinder.
Rejoinder?
Stop, huh?
You didn't get it?
No, nothing. I'm sorry. I'll check. Affidavit in opposition was filed in the month of February. This much I know. But rejoinder is not with us.
And some is
filed it on
and some is
3rd
some is
February
that-
2026.
and some is that he has the respondent has
I have
filed.
served, I have
Mr.
filed
Tiwari assisted by
February.
you are assisting.
Anil Tungan. Anil Tungan. Anil
Anil
Tungan.
Tungan.
Anil Tungan.
Hmm. And some is that the affidavit has already been filed in respect of the respondent number 4 and 5 in WPC number 139.
Yes.
Yes.
566 also.
These cases I am not aware of. I have no idea what these cases
Okay,
are.
okay.
I
No,
don't think
sorry,
NHPC
sorry.
is the party
No,
here.
not.
Yes,
okay.
yes, NHPC is not a party.
That is 11, huh?
But I have also filed my rejoinder to the affidavit filed by the NSPC.
Already filed.
Yes.
That may not I'll find out, but there is no difficulty. I'll talk to Mr. Patel about it. If it is not there, I'm sure my friend will give me.
Okay, stop. Then, no, it's because in any case, the state is praying.
State has to file. State has to file, Milord.
No, not yet filed in item 10. In 11, what happened?
11 also we.
11 also?
File, yes.
Okay, in both then, huh?
Both.
11 also.
No, this was
3 weeks time.
long back, almost
3 weeks
more
time,
than
huh?
1.5 years back.
Hmm.
They have chosen not to file it.
Then what do we do with the respondent 4 and 5 in item 10? If you don't want your name to be, Mr. Rinching is not there.
Let us do one
That's
thing.
an informal arrangement. Milord, that's an informal arrangement between me and Mr.
No, one is it. Yes.
Milord, that's an informal arrangement between I myself and Mr. Patel to help him out so that there is no difficulty. Lordship may simply defer the matter for a week. Let it come after a week. In the meantime, with my friend, I will sort out the matter.
Yes.
Okay. As Mr. Patin,
Otherwise, we can say that Mr. Patin has sought 1 week's time.
Yes,
So
yes,
Mr.
that's
Patin,
better.
Mr. Patin,
We will
Mr.
do it.
Patin.
Yes.
Sami said he has taken steps upon the respondent number 4 and 5 by way of the service. However,
And
the
also by registered,
compliance through
by
register,
registered post also.
as well as by a registered post. However,
That
the
24
same is still awaited. And in view of that, Mr. Patin prays for the 1 week time
Yes.
to file compliance affidavit.
Oh, yes,
Okay.
that's better.
As prayed for, is the matter again after 1 week. So that will be only for engagement because the state.
Oh, yes,
state
yes, we'll get the
is-
engagement.
Okay, then. After a week.
A particular date may be next Wednesday.
Date. So then, would
Next
be
Wednesday, which date? Just a minute. Next Wednesday
would be
will be
19. Okay, 19.
19th is all right. 19th is all.
No, 19. Okay, 19.
All right.
Okay.
Milord, my
Then what
presence may
12 to
kindly be
14?
shown in item 11. I hope in item 11, Lordship.
Yes.
Yes.
In both, I said. In In 11, I said, huh?
Item number 12 to 14.
Sitting in this matter. Well, the fact is,
Hmm.
the petitioner was appointed as assistant engineer, then promoted to executive engineer,
Mhm.
and then to the superintending engineer, and then finally to the chief engineer
Mhm.
in the PhD department.
Mhm.
Then comes what had happened was when he was about to be separated from the services, my lord,
Mhm.
he was served with an impugned recovery order at page 35, my lord. 2011, 2025, 69. Intimation letter for my superannuation, my lord,
Page 25.
page 25. My lord.
Yeah.
That, my lord, kindly see thereafter on the
No, so, page 25, your name,
35,
35.
35,
Okay.
2011, 2011.
Your name,
Gauhati.
the intimation
Yes.
regarding superannuation, when? 28/2,
Yes,
now retired.
now retired.
Okay.
So then what happened is, my lord, thereafter, this at page 36, my lord, 16,
Just a minute, huh?
16/9/2025, the impugned recovery order was issued, my lord,
36, page 36,
36, my lord.
recovery order. See, this is, must be,
My lord,
About
down
10.
below, my lord, we'll see that last box,
therefore.
the last box, my lord,
Hmm.
right.
Hmm.
Then due to non-passing of department account examination, my lord.
Hmm.
This is the only problem, my lord. So
Mhm.
now, in one of the matter, my lord, I appeared, and then my brother Tapin also appeared
Mhm.
on the same department,
Hmm.
and then this court has set aside the recovery order, my lord. Just I placed this to save the time, my lord.
Okay.
Only Tapo judgment, and there is one more. You want? नहीं हो जाएगा तमोली तको का
Mhm.
हैं?
Yes. Hmm.
तमोली तको का जजमेंट दे दो उसको. But this has quoted Whitewasser and Jagesar Sahu judgment, which
Hmm.
my brother Tapin opposed, but this honorable court did
This,
not
I think,
similar
within 1 year. Hmm.
same order may be passed. Yes.
We'll just see, na?
Yes.
This is
हो जाएगा.
subsequent order, and then ground is that. Just a minute. Huh? This is PhD's case.
Same. But
What is the amount?
amount was
Okay.
4 lakhs something.
Where do we find the amount here?
Impugn order, my lord. In the impugn order, my lord, 36, my lord, will find impugn order.
Page 36. Total amount would be?
Total amount is 4 lakhs something. I remember. 42.
Page 42.
Yes, my lord.
Just a minute. Let me just. Okay.
42 bottom, my lord, will see.
Yes, yes.
4 lakhs 56,709
Okay.
rupees. Other
Just a
cases.
minute. Huh?
Hmm. Huh. They are all from PhD department only, on the same thing.
In the PhD department,
Yes.
it appears in all
All.
such cases.
Impugn-
Because
But not, except impugn order is different in
Mhm.
the two matters. And amount is different. Amount will indicate and give. Nikal the amount.
all the provisions quoted the same.
Yes, yes.
Just a minute. Huh? Now he was posted at
He retired as a chief engineer.
retired as a chief engineer. Where?
On
With John,
Second February. 28th February, my lord. Page
written
35.
28 Feb,
28th February 2026.
let me just take her retire on
28th February 2026.
28 to 2026.
Already.
Okay, age chief engineer
Chief engineer.
with John.
Just 1 second, my lord. Department of the following.
Where was the notice?
Notice 35. Notice.
Page 35, okay. Deputy Commissioner.
लेकिन उसमें कुछ लिखा नहीं from which मतलब sent chief engineer Western Zone PhD Itanagar.
Western Zone,
PhD Itanagar.
Itanagar.
Yes.
Okay. And then
Okay.
when he was initially appointed?
Initially, he was appointed on 31/01/1991. My election 1 series. My lord, may I kindly take assistance of my synopsis.
No, synopsis is there.
Yes, sir.
Mhm.
Whole paragraph. No. Fifth paragraph, my lord, of the read petition is more appropriate.
Round. Fifth paragraph of
Fifth
read
paragraph,
petition.
yes. Fifth paragraph, page 7.
Yes,
The
31.
he was initially appointed as assistant engineer. Detail is given there. Everything. I'll guess it. Yeah, okay.
Here, detail of his promotion also given here.
Yes, everything.
Okay.
Yeah.
Poem is same.
Yes, madam. This poem is same. White Wasser and Jogeshwar Sao judgment also.
And then the CPW manual, etc. These all are same. And then he have never appeared in the departmental examination,
Probably not.
the account examination, never appeared.
No, he appeared, but after this promotion from executive to SC in between, I think he has not
Okay.
appeared. A to executive, because that's all right. This item 13.
There was no case of any RTI application in this case?
No.
No. So deduction order is just a minute. 16.
16. Ali. Right, and make that difference. That
Who is respondent number 5 here?
R5. R5, I think audit and pension.
It's only after respondent number 4 in your case.
Four.
Four lakhs 56,709.
This guy.
From sorry, while authorizing the payment of on the basis of the recommendation of the respondent for this is not necessary.
I just go to terminal yet, okay? I just go.
Was there any was there anything also about
No departmental inquiry, nothing.
no this one wrong fixation of the basic, any case of wrong fixation of the basic pay or excess? Not the case. I think not exactly similar. I think this case.
Increment, only increments.
Hmm.
Increments are given generally after clearance of account examination
Yes,
by
yes.
the engineers.
But unless you clear the account examination, it was actually he should not have been given. But here is the case where he was given.
The department's fault, and before,
It was a fault of the department,
before 1 year of retirement, you
not
cannot.
properly maintained. He was promoted to the post of
Amount
executive engineer as.
Eh.
He was promoted as executive engineer on
Pair of 5 level.
pair of 5.
Pair of no, no, it's fine.
22/6, 22/1.
22/6. Hmm.
Oh, do that. Oh, it's becomes.
Whether you have also submitted representation here?
Yes, yes, madam.
So dated?
Dated 20, no, no. Wait, wait, Tabatani gonna close. No. 2011, 2011, madam, same representation. 2011,
2011,
2025.
2025. Okay. So recovery from period, which period to which period?
Area second.
Have you mentioned, whether, in the impugn order mentioned? Impugn order?
36.
Period. Can you just assist from which period to which?
1/1/2002 to 26/11.
1/1/2002 to
26/2011.
20.
26/2011.
2011.
20, yes. 2020 June 2011.
Okay.
Page 36 bottom loss.
Till the promotion of the petitioner as a superintendent SC,
to chief engineer.
when he was promoted as SC.
Executive engineer to SC.
When?
That is, Lordship, he was executive engineer in the year 2001 and promoted to SC
On
30/5/2011, Lordship.
okay.
On ad hoc basis, Lordship. SC on ad hoc.
There are also some case referred, Ketang, Tagung Ketang. Keta. PHE case.
In his case, lordship, exempted lordship. He was
Okay, comparing with that.
Yes, lordship. He was exempted, but
Okay.
in case of this Kamuli Tapo case, lordship, no exemption was given to the given to Kamuli Tapo lordship by that farming law.
Okay.
Lordship, for clarity and for better understanding,
Mhm.
I'll take up the affidavit filed by respondent over 4. And come to page 62, Lordship, in Excel P. Page 62
Yes.
in Excel P. This is the order dated 19 July 2000.
Yes, yes.
This is the order under which Lordship account examinations it was made compulsory
Okay.
in the department.
Mhm.
So Lordship will find here, pursuant to the adoption of norms and procedure of CPW manual by all works department under the government of Arunachal Pradesh, the departmental examiner in respect of assistant engineer and junior engineer in the department of PHE,
Mhm.
an order is hereby enforced as per CPW manual so and so and so and so and so.
Mhm.
Here, Lordship, the petitioner was the executive engineer, Lordship. So this is applicable for assistant engineer and
J.
engineer. For executive is not applicable.
Executive not applicable.
For executive is not applicable.
I think assistant engineer, junior engineer
engineer.
in the department of, this was in the
Therefore,
2000.
Judgment,
Uh,
this honorable court has held, Lordship, so far this order is concerned, it's not applicable for the executive engineer.
Not for the executive engineer, but then
Petitioner
whether
was
he,
already promoted by that time, Lordship.
no, but while he was serving as J and A, he did not,
But that, because by this order only this rule was brought in, Lordship. Prior
No.
to this order,
prior to this,
no order was there.
he was not,
By
but
this
at the
order,
time of existence of, I think this, during this 2000,
Lordship.
when this notification came, that time he was J or A, I think.
No, but assistant engineer.
Sorry, assistant engineer. He would, he is supposed to pass the account examination then,
Lordship. But recovery,
but then he did not.
but the recovery sort is from 2002, Lordship.
2000.
Okay, 2002.
2002 to 2011. By that time,
So-
the petitioner was already promoted to executive
Executive
engineer.
engineer.
Executive engineer, he was promoted as executive engineer on
On 2/6/2001.
2001.
Yes.
One.
Okay, then he was already AE.
E. So the recovery sort is from 2002 to
Uh-huh.
2011 also.
Okay, no, is it the same case? No, I think not
Same,
similar. His case also similar.
same case as
Okay.
Tamolita calls.
Be careful, don't petition as well as the document also peruse the input order date is so and so. Order date is and so. Assistant engineer on
Assistant engineer on 31st January 1991.
91.
Executive engineer,
he was on regular basis. I think.
regular one,
Okay, not on ad hoc.
not on it.
And
22/6,
it's not a case of permanent position.
no,
Okay, and he was
22/6,
regularized.
2001, he was promoted to
Executive engineer, promoted
22/6.
executive engineer as on
22/6,
Hmm.
2001.
2000, yes,
Then
and for regularized. Superintendent engineer on
35, 2011 on ad hoc basis. Thereafter there was a DPC and his service was regularized.
okay.
Then Then he was promoted, SC, he was regularized on SC, regularized as SC on 27/2012, my lord. 27/2012.
SC, regular is SC,
Superintendent engineer on 27/2012.
SC on
27,
7,
2012,
2012.
and then promoted to chief engineer on 14/7/2025.
CE on
14/4/2025.
2025. And superannuated on?
Superannuated on
Oh,
28 February 2020.
yes, 26.
Then he was given intimation letter on 20/11/2025. Then the impugn recovery order was passed on 16/9/2025. Then he submitted representation on 20/11/2025.
2011.
Yes, no, 20/11/2025,
Mm,
saying that you cannot recover
mhm,
in view of the judgment by this act.
mhm.
And the whitewasher and all those things we have given. Then, my lord, this office memorandum, it clarifies everything.
Mhm.
That is reproduced in the Tamil Court judgment. That's my lord.
Okay.
That clause 3 and 4, my lord, will find. That OM dated
Mhm.
02/03/2016, my lord.
Auditor of the director issued letter on
That is, no,
auditor for director of audit and
auditor has
pension
not given
issued
us
letter on
no, but on the base, I think in this case, they have not served any,
not issued.
not issued.
Okay. Mm.
My lord will have a glance of whitewasher judgment.
Yes,
Everything
yes.
will be clear.
There this. Okay.
And Jogesar Sahu, my lord, has reiterated all the principles.
Okay. Hard.
It is Jogesar Sahu.
Hard, Mr. E.D. Tara. Lanis Senior Counsel, assisted by Mr. Baum.
Whitewasher.
Baum Lani Counsel for the petitioner. Also heard Mr. Pins, Planet Senior Government Advocate for the state respondent. Oh, what are these?
No, just whitewasher and the Jogesar Sahu judgment I have given.
Okay,
If my
okay.
lord want to peruse those.
Okay, okay.
Yes,
Hmm. Paragraph have you highlighted, Mr. Baum? Highlight.
Whitewasher.
Yes, mostly discussed.
Discussed.
Discuss. Okay.
It's
Para
already
18.
there.
Okay. And district, Jogeshwar Para? Okay, okay.
You indicate and give it.
Reflected.
18, my lord.
Here also 18?
Yes.
Okay. Mr. Stapinani, government advocate, staff, Okay. So I'll pass order.
Yes.
Hmm.
My lord, this item number 13 also is false. Only I will have to assist my lord on the dates.
Yes.
That one 14 different.
Hmm.
This is Joyangu.
Item,
Item 14,
okay,
13.
13.
Hmm.
Here also,
But this gentleman was appointed as
just a minute.
Uh.
Then here, can you just, Mr. Baum, those are the required information. date of appointment, all those list of that.
Paragraph 5 is
5 is okay.
5
Here also he was in what capacity?
engineer. He entered service as a junior engineer
Okay,
in 1992.
just a minute. Huh?
Paragraph 5, my lord, will see.
That will be better if you can. Huh? So the date of appointment, date of promotion, date of retirement, issue, notice issued at the date, huh? And recovery order dated. That is different. So those things you just furnish it.
Correct.
Okay.
He will do it.
Okay. Similar order. The furnish here in item
13 and 14.
13 and 14.
Yes.
Okay.
See, this so far item number 14 is concerned. Here the text is little different also.
Is it?
Because the petitioner was promoted as E only in year 2013 also. If this order of 2000 is applicable for A and JE, JE and AE, here the petitioner was A only also.
So he
was promoted as A on 3/4/2001. So in that case, this order will be applicable to this.
No, but not, that's the law settled in Tamulitako, referring to Whitewasser and Jageshwar Sahu, is that you cannot initiate recovery those who are going to retire within a period of 1 year. That is the law. So therefore, the fact, even if there is a guidelines, that cannot be applicable, and that would be different.
It should have been issued prior to that,
prior
to 1 year, prior to his the nearing to his retirement. Actually,
that's that.
So at the later stage, at the back end of his service, it cannot be.
Cannot.
I think the guidelines.
That is Whitewasser and Mohammed Rafiq judgment and Jogeshwar Sahu, which was referred in Tamulitako case. So therefore, the ground will not exist because my brother has.
If you have confusion, want this item another date, we can. Otherwise, 14.
This can be taken up some other date also. This particular.
We'll see that. This
because there are so many judgment also. Now, whether the recovery poses any hardship to the retiring.
Otherwise, this also, because this was issued, he retired when he retired.
Similar to say 20, this is Tawatini, Joyangu. This man retired on the same day, 28 February 2026.
And then notice was issued.
Notice was
Recovery notice.
Recovery was on 02/07/2025.
25. Okay, when he had hardly left 1 year.
In 1 year only.
So
therefore, the law will.
So what do you say?
Some other day.
No, because the law is settled, and my brother Tapin has already, because submitted, and that his submission was not accepted by the court, and this court has laid down the law, so therefore he cannot go beyond that.
Yes, it can be taken up tomorrow. I'm not.
Okay, what we'll do is this 2, the 12 and 13 will be done. So 14 will just let him clarify once. If he is satisfied, similar order will be passed. Okay, and for these also, with these 2 also, you give the detail if it is possible today. Okay.
But para 5 contains everything.
Okay.
Normally, like in my whenever I settle the writ petition, I make it very sure in my synopsis and one particular paragraph, the details.
Entire details of the. Okay.
Here, paragraph 5, you can see all the judgment.
Okay. We'll see. But then still, if it is possible, we'll see. We'll compare with. Okay. And this then we'll fix tomorrow.
Tomorrow, I think.
No, tomorrow is DV day. Day after tomorrow?
Day after tomorrow.
Day after tomorrow.
I'm satisfied.
Only just let him satisfy. Otherwise, no. Okay. Then 12 and 13 dispose. 14 is prayed for by Mr. T. Tara, Lana Senior Counsel, assisted by Mr. Zibam, Lana Counsel for the petitioner stuff. Mr. Kapin, Lana Senior Government Advocate, raised for listing this matter on Friday.
Yes.
Okay. The prayer accepted. Okay, list matter. According on 12, on Friday on 14. Okay.
So 1 minute left.
Item number 15.
Okay.
My lord,
Yes.
this matter, my lord, the petitioner was initially appointed as a inspector, my lord, under Trade and Commerce, my lord, on 12th August 2011.
Whether respondent number 1, 2, 3 file affidavit.
My lord, you have filed the affidavit.
File.
Yes, my lord. My lord, this is my respectful submission, my lord. This is the covered up case, my lord. The similar situated, my lord, same type of nature, my lord. Again, same department. The coordinated bench has already passed the judgment, my lord, directing to review the DPC because the what law says, my lord, that officiating, because he was given officiating promotion, my lord, that officiating length of service has to be considered, my lord. So recently also, my lord, the same department, my lord, this honorable court, my lord, directed to conduct a review DPC, my lord, and that was already done, my lord. My lord, just for
ये इसको देख देखो
same day, my lord, that relying.
I could find a affidavit of respondent number 4. Where is the affidavit of respondent number 1, 2, and 3? Whether file?
It's covered up, my lord. I think. I believe it is same.
Now, who are these respondent number 1, 2, and 3? State.
Statement.
Minister Trade and Commerce, Secretary. 4 is filed, the Director, Trade Commerce. Is it for all?
Director.
This is for the direct respondent number 4. That's a director trade and commerce lawsuit.
And what about the 1,
It
2,
will,
and
it
3?
will cover the lawsuit.
Covered?
Covered.
Okay, no problem.
Fine.
Then it's fine.
My lord, this similar, my lord, the same.
Furnish a copy.
Well, I'll have the furnish, my lord.
Okay, sir.
Just, my lord, this brief fact is similar only, my lord.
Okay.
Before coming to this brief fact, my lord, I just highlight the factual fact of this. There, my lord, the petitioner was appointed as the inspector, my lord. Pro-selection process, the base 33 is the initial appointment. And thereafter, my lord, the next promotion to the post from inspector, the higher post is trade development officer, man. Trade development officer rule, RR recruitment rule 2010, my lord. It is there, my lord. As per rule 2020, my lord, the criteria for promotion, my lord. Under that rule, my lord, 6 years regular service as an inspector, and the pay scale is 42, my lord. 4,200, my lord. Thereafter, my lord, in 2015, the petitioner was promoted, given officiating promotion to the post of trade development officer, my lord, on 21/12/2015 with a pay scale, my lord. My lord, it's important, my lord, with pay scale of trade development officer.
Mr. Tahu, we may have to continue at 2, I think.
My lord.
Then we'll continue at 2.
Close.
My lord.
Okay. Yes, Mr.
Yes. My lord, just before referring this decision, my lord.
Who was standing?
It's covered up, my lord. I'll just highlight the fact only. Page 33 is the initial appointment of the petitioner as an inspector, trade and commerce, my lord.
Who was standing?
My lord. Page 33.
On the other side, someone.
Other side, my lord. Tapin, he's coming.
Tapin was there.
Yes, ma'am.
Just
I
a
will
minute,
furnish
this
the
is
judgment
regarding,
copy.
this is regarding in brief, this is regarding,
My lord, this is just only to know the brief, in a factual aspect of the case. It
okay,
is always, it is covered up by the risk judgment only.
Okay.
That's why, my lord, just to understand this present case, my lord.
Mhm.
Page 33, by this order dated 12 August
Page 33?
2011. He was,
33.
yes, my lord.
What is this order for?
It is his initial appointment on selection,
Just a
selection
minute, huh?
process.
Let me just, you are trying to get it disposed of.
Yes, my lord.
Then
Because
just
it's already
wait, huh?
covered up matter, my lord.
Mhm.
Only to,
Covered case.
yes, covered case.
Okay, let me just, this is appointment, initial appointment order.
Yes, madam.
Date?
Dated 12 August 2011 as an Inspector Trade and Commerce.
2011,
Yes, my lord.
appointment.
Yes, my lord.
Hmm.
My lord, now next promotional post from Inspector Trade and Commerce is, my lord, to the post of Trade Development Officer, my lord. My lord, there's a rule, my lord, set of rules, recruitment rule 2010, my lord, at page 34, my lord. See, this is the recruitment rule for next promotional post from Inspector Trade and Commerce to the Trade and Development Officer,
Which
Rule
one?
2010, post rule. Down below, my lord, column 4, my lord.
Column.
Great
Is
pay,
this clear
pay-
copy?
My lord, this is regarding this rules called the Development Officer Recruitment Rule 2010, my lord. Now, in the schedule, my lord, schedule 4, my lord.
Just a minute. He is arguing for disposal of the matter, Mr. Tapu.
Close.
My lord, this is
It's
covered up,
okay,
my lord, my lord.
covered case, okay, no?
It's,
Otherwise,
Only I'll just clarify certain fact, only that aspect only, my lord.
okay.
Just to point
No,
out.
no,
that
which
point,
one?
my lord.
Page 34?
Page 34, my lord, schedule 4, my lord.
Schedule 4.
my lord. This is a pay scale, pay brand, my lord. A great pay is
Schedule
400.
column 4.
Yes, my lord.
In the
Great pay,
schedule
my lord.
column 4, grade pay band.
Great,
Grade pay.
yes, my lord. Great pay to 4,200, my lord. Great
Mhm.
pay of the Trade and Development Officer, my lord. Why I'm referring, my lord, because
9,302,
yes, the
4,000.
pay grade, my lord. This is an important pay grade, my lord. 4,200, my lord. It's a pay grade, my lord. Now,
Grade pay.
yes, my lord.
Which grade pay?
Now, in the meantime, my lord, by 31st December 2015, at page 30, my type copy is page 37.
So just a minute, in your appointment, what was the grade pay mentioned?
My lord, that is,
932, 40, same.
yes, my lord, no, not same. Because next promotional post is Trade and Development Officer.
No, these 12, 8, your appointment, your grade pay. Your pay
This is
scale,
for the
pay
next
scale.
promotional post. I haven't given even this pay grade, my lord, that too so only.
Mhm.
This pay grade, my lord, at page 37 type copy, my lord, see, I was already granted, I was given officiating promotion to the post of,
No, after 34, 37 comes.
yes, my lord.
Okay, this is regarding what?
Regarding, that's my officiating promotion to the post of Trade and Development Officer
2010.
with pay grade, my lord.
2010.
Item number, serial number 2, my lord.
Just
is-
a minute. Okay.
I've been granted pay grade, my lord.
Just a minute.
Pay grade, with pay grade of,
This is item, this one,
Serial
page
number two.
37.
yes, my lord, 37, serial number 2, my lord.
Serial number
Pay
2.
gr- Yes, with
The
the,
serial number 2 is you,
yes, my lord,
Tangli Mosang.
yes. The
Okay,
post
so
of
this
Trade
is
Development Officer.
2015.
Yes, my lord,
Trade Development Officer.
yes, with pay grade, my lord. Pay grade of the trade,
Pay band is this one, grade pay is 4,200.
yes, it was granted. This, my lord, sit at page 34, it's a pay grade of the,
34 or 37?
my lord, this is 37 only.
Mm-hmm.
And this pay grade is the pay grade of the,
Initial appointment.
no, promotional post of Trade and Development Officer.
Okay. This is starting grade pay.
Yes,
Okay.
I was given officiating promotion, not without pay, but with pay scale of the Trade and Development Officer, my lord. That is just to show that, man.
Mm-hmm.
I was given officiating promotion with pay grade, my lord, of Trade Development Officer. from
Just
the-
this is officiating order,
Yes, my lord.
officiating promotion.
Yes, my lord.
Now, your initial appointment,
Now, is it Inspector Trade and Commerce?
just a minute, for my clarification. Your initial appointment, joining the posting, pay ban or from rupees 9,300 and the end is 4,200. This is same. If it,
No,
this
no,
is the promotional post.
Promotional pay is a higher, my lord.
Higher, but then the scale is same.
My lord, pay grade is higher.
Where?
My lord, the pay grade will see, my lord.
Grade pay.
My lord,
Which one is pay? It's a grade. There is a pay band and grade pay.
grade pay, my lord.
Grade pay is rupees 4,200.
My lord.
So, pay scale for
My lord,
9,000.
it's a fair matter, but in any case, my lord, I was granted. Now now I'm not harping. This is not much relevant. My lord,
Okay.
my point
Your
is,
post is
yes,
relevant.
post is relevant. I was
Pay
given,
post is trade development officer.
yes, I was given
Your
officially
initial appointment was in the post of,
Inspector Trade and Commerce, my lord.
just a minute, Inspector Trade and Commerce.
Yes. Now,
Hmm.
officiating promotion, I was given as a Trade Development Officer on 21 December 2015 at pay 37, my lord.
Hmm.
Page 37, my lord. My lord,
Hmm.
as
Yes.
per the trade development, the recruitment rule of Trade Development Officer 2010, my lord,
Hmm.
the qualifying length of service for the to the post of Trade Development Officer from the inspector is, my lord, 6 years.
Okay.
It was 6. But I was given, since it was fallen back in, I was given officiating
Okay.
on 15 in the year 15, 2015, my lord.
Before you achieve the
Yes,
eligibility criteria.
my lord, that apart, my lord,
Where do we find that rule? 6
Uh,
years?
6 years, my lord, will see at page 35.
Hmm. Which one?
By 12, column 12, my lord, by promotion, that 50-50, my lord.
12?
By promotion from
Hmm.
the post of Inspector Trade and Commerce of the department who have completed the 6 years of regular service in the grade, my lord.
Hmm. Hmm.
Now, my lord, the government of Arunachal Pradesh, they have notified the office memorandum directing all the head of department to conduct a DPC within every 6 months, man. At page 38 to 39, 38, man, will see the office memorandum issued by the government, 16 June 2016, and relevant page at page 39, my lord, directing the all head of department to conduct DPC in every 6 months, my lord.
Hmm. It's
Now,
okay.
as per
Hmm.
as per this recruitment rule, my lord, as per this office memorandum, my lord, every 6 months DPC has to be held, my lord. Now, my lord, in the year 2017,
Hmm.
at page 40, my lord, see 41, relevant type copy of 41, my lord, the Trade Development Officer recruitment rule, it was amended. Page 41, my lord, type copy. Trade Development Recruitment Rule Officer Amendment Rule 2017, it was, my lord, enforced, my lord, by notification 2018, my lord. Now, serial number, my lord, see at Roman 5 A, my lord. This is
RR amended.
yes, amended. And by this RR, my lord,
Hmm.
qualifying length for promotion to the Trade Development Officer has been reduced to 5, my lord. Earlier, as per 2010, it was
5 years.
It was 6. Now, by this latest amendment, my 2017 amendment,
Hmm.
the qualifying length of Inspector Trade and Commerce for next promotional post to the Trade Development Officer is 5 years, man. Now,
Hmm.
if we go by this new latest amendment, my lord,
Hmm.
5, if it is treated of 5 years latest, my lord, the petitioner actually eligible for the, as per this new rules, eligible for the post of, for promotion to the next higher post, that is Trade Development Officer, on 12 August 2016.
No, but then rule, this came only in two thousand
That is,
eighteen.
my lord, that's is better because why I'm saying this, my lord, even in that, I'm even not insisting that part, just to apprise this point only, because this DPC, my lord, it was held lately, my lord. It was held after enforcement of this 2017 RR, my lord, at page 42, my lord. Page 42, the DPC was held on 1st July, my lord. 1st July 2020, my lord. Because as per the government office memorandum, my lord, it should have been held in every 6 months, but that has not been done. And subsequently at page 46, my lord.
DPC held on 2020.
Yes, my lord. 1st July 2020.
Yes, yes.
Based on this DPC, my lord, I was given promotion at page 46, my lord, on 5th August 2020, with effect from date of DPC. Page 46.
This is your promotion.
Yes, my promotion. Page 46. My lord, I'm agree by this promotion, my lord, saying that since I was already eligible and I was given officiating promotion with pay grade, my lord, my promotion should have been, my officiating length of service as a trade development officer should have been counted for recording the seniority, because there's department's not going to incur any financial implication because I was already given pay grade, my lord. So that is, I'm asking for, my lord, request, I requested the authority, let this DPC be reviewed and my seniority be counted from counting my officiating service, my lord, as a trade development officer, my lord.
Officiating on that?
Officiating dated, my lord, 21/12/2015.
No, that may not be possible.
Yes, sir, my lord, that is the, but
because
if you go by, if you go by, my lord, this RR, my lord,
how
it would be, my lord.
By then you have only, by then you will have.
Yes, sir. Even I'm not insisting that, but even by the rule, all my lord, you rule also on I'm eligible, my lord, already eligible. 12 August 2017, man.
Okay.
12 August 17, man.
17 or 18?
17, 17. That department also admit that part, they have clarified, man.
12?
12.
No, this notification came only on 14/2/2018. Notification reducing the length of service.
Yes, that's
from
why
6 to
without applying that latest RR, my lord, if you go by rule 2010, my lord.
6 years.
6 years. Then 6 years, then I'm eligible.
You complete 6 years when?
Yes, 6
When?
years on 12 August 2017.
Okay.
12 August. The department has clarified that part, man. 12 August 2017. So
12 August.
yes, man.
Completed 12 August.
12 August 2017.
Okay, so
Eligible for promotion to the next month as per existing, as per rule available at that point of time.
okay, by then this new notification did not come.
Yes, my lord. Now,
so what is your prayer?
now my lord, my prayer is to review this my promotion order at page 46, my lord, counting my seniority from that when I was already eligible, my lord.
Okay, just a minute.
Instead of 1st July 2020, it should have been day when I was already eligible, my lord. That is going by the department stand, my lord, 12 August 2017.
So your prayer is from 12 August.
Yes, my lord, 12 August 2017.
2017.
Yeah, because this is the government, they have clarified, man. It is of no use of repeating it also, because that the government, they have clarified that part.
Okay.
Now, in this regard, my lord, this is that is the judgment that just I placed, my lord.
Okay.
That is
similar case.
Similar, my lord.
Ah.
Now, I mark it, my lord, right from page para 9, my lord. Same department, my decision of the Supreme Court, my lord, Harish Chandran and Chandrasekhar Singh and S. Suman, this all decision was relied. Having relied on this decision, my page 6, para 9, my lord. This is the legal proposition that can be crystallized from the aforementioned decision is that officiating service rendered by employee cannot be ignored or discarded by the state authority, and length of service on officiating must be counted and computed for the purpose of recording seniority in the service. 10, ma'am. In the instant case, petitioner was given officiating promotion to the post of Deputy Director Trade and Commerce with effect from 4/12/2015.
And in your case?
And in my case, my lord, I was given officiating on 21/12/2015. 21/12/2015, madam. And has also given the pay scale. I also given pay scale, madam. Since in my case, since 21/12/2000, from that of officiating appointment, I was given pay scale, madam. Now, is provided with office memorandum dated 16 June 2026, my lord. That is the office memorandum of the government directing all the health department, head of department to conduct a DPC within every 6 months, my lord.
But
That
not-
was not done. No DPC was conducted for consideration for regular promotion of the petitioner to the post of Deputy Director, Trade and Commerce, and the DPC could not be held till 09/11/2019. Well, the DPC was conducted on, in
your case?
in my case, it was held on 1st July 2020, madam. 1st July 2020.
But 2020.
Yes, madam. In the present case, madam, it was conducted.
2019, your case was not considered.
Madam, no. In the present case, madam, in my case, madam, instead of giving me the promotion from the date of DPC, my service, the length of service that I rendered as a officiating promotion, as a officiating trade development officer should have been taken into account, ma'am. That has not been taken into account.
No, this is the same department.
Yes, same department, my lord.
Okay, but in his case, it was, could not be
It
held
was-
on. Okay, could not be
DPC was
held.
held,
till-
madam.
Okay, okay.
DPC was held and promoted on 5/12/2019, madam.
5th, 12th, DPC was held in your case also.
In my case, DPC was held on 1st July 2020, and based on that recommendation, I was appointed as a DTO.
DPC was held on 1st July
Yes, 2020.
2020.
In my case, and based on the recommendation of this DPC.
Okay, and then you otherwise were eligible on 17.
17, madam.
12/8.
Yes, 12/8/2017, madam, as per rule, madam. Then that was,
17.
that is the case, my scenario, na? So much. Now, without considering the length of the-
But you were ultimately promoted to
the
on
post-
5 August.
Yes, madam, by appointment, madam, basing on recommendation made by DPC from date of DPC, madam. That is 1st July 2020. Now, this is almost covered up, my lord. Para 11, my lord.
Just a minute.
Yes.
What is this? Officiating basis on Deputy Trading Commerce since
Without considering the
render your service since when was that? Officiating capacity since when?
21/12/2015, madam.
21/12,
Ah,
2015.
yes.
Okay.
And as per rule, I already acquired the eligible length of service on or qualified by 12 August 2017. Now, my lord, since the petitioner at 11,
But 21/12/2015, you did not acquire
my lord, that's a big.
qualifying period.
Yes, I was given officiating, my lord. That's even I'm not
Officiating
asking for
also.
that, my lord. At least the day when I qualified, attend eligibility business, I was serving an officiating, my lord. That should be considered. That should have been considered, my lord. Now, para 11, my lord. Since the petitioner has rendered his service as a Deputy Director, Trade and Commerce on officiating basis since so and so 4/12/2015, And since he has been given regular pay scale of the Deputy Director, Trade and Commerce and other service benefit, since he had acquired a length of service 5 years for being promoted to the post of Deputy Director, this court is of the view that period of service rendered by him since 4/12/2015 ought to have been considered by DPC held on 5th November 2019, and since it was not considered by the DPC, serious prejudice is caused to him.
In your case, this 4/12/15 should be?
In my case, I claim for
Your service rendered since DP, your, your,
I appointed as I was appointed as officiating my lord
officiating since?
since 21/12/2015.
Hmm.
But as per recruitment rule, madam, I acquired completed the length of service by 12 August 2017. Madam. If from initial date of appointment is not considered, at least my the period at that when I already acquired the length of service, that should have been
In your case, DPC was held on?
held on my lord 1st July
7, okay, 2020.
2020. Yes.
Okay.
Now, para 12, my lord, in this, ultimately, my lord, under aforesaid facts and circumstances, taking note of the submission of the learned advocate both sides and also the legal proposition as discussed here and above, this court is inclined to allow this petition. Respondent authority are directed to constitute a DPC to review the case of the petitioner for being promoted to the post of Deputy Director, Trade and Commerce, with effect from the date of his officiating promotion, so on which he was promoted as an officiating Deputy Director, keeping in mind the legal proposition enunciated here and above. The above exercise has to be carried out within the period of 3 months from that of certified receipt of certificate.
So in your case, it should be 12/8 according to you, 12/8/2017.
If even exceeding the clarification made by department, madam, as per rules.
Where the department has made clarification
Madam, at page para 8, madam,
of?
of their affidavit, page 73, madam, of their affidavit, madam. I'm exceeding that part, madam, accepting that.
Para 8.
Yes, madam. Para page para 8, madam.
1/7/2020. Order 6 years
7.
qualifying
Madam, from
service.
bottom, from madam, 1, 2, 3. From bottom, madam, 5, madam, 1, 2, 3, 4, 5. Although, madam, although his 6 years qualifying service for promotion to the post of Trade Development Officer fulfilled on 12/8/2017, madam. The sitting of departmental promotion got delayed due to delay in furnishing NOC from ADC Jarampur. Madam, that part, madam, I'm exceeding, madam, as per rule, madam, although I was given office thing prior to that, but as per rule, madam, at least I'm entitled for my office things length of service to be counted right, at least from the 12 August 2017.
Okay.
That is my respectful submission, madam.
Okay.
And this.
So this direction, anything else?
Madam, that is my respect. In the line of this, madam, this can be disposed of because the similar cases, madam, under same department, madam, this already it has been considered.
So his case has been considered, and also the department has also passed any order?
No, madam, basing on this, madam, the department has already implemented, madam, this order.
Okay. Yes. So.
Lordship, yes, subject of the consideration is always lies with the authority person.
Yes, direct.
So I differ with this, though it's a judgment, it's not challenged before the honorable division bench. But basically, as I've said that, so for consideration is the subject matter of the authority.
Mhm.
If this honor court already fixed from this particular date, the regulation has to be made,
Mhm.
then nothing is left to the authority.
Mhm.
The exercise of the authority would be a mere function,
Okay,
mere formalities.
This is paragraph 8. You said a regulation to the post of trade company.
Here, just
Although his 6 years qualifying service for promotion, you admitted that the sitting of departmental promotion
we have submitted
got delayed.
this statement comes from the petitioner
Hmm.
that he has completed 6 years,
Mm, mm, mm.
15,
Mhm.
sorry, 16.
Mm.
So that in regards to that statement, we have made clear application lawsuit.
And
6 years
Mm.
rate of services he has completed in the year 2017 lawsuit. No,
Then in the same department.
just what I'm trying to point out is lawsuit.
Mm.
Uh, this matter may be disposed of or with direction to the authority
Mm.
to constitute a review GPC
Mhm.
to consider the case of the petitioner as per the law.
My lord. My lord, that will.
As per the law. Because that has to be the what I understand, that has to be the order by this law court also.
Time period, time at this, my lord, time frame may be granted in that case, my lord. Obviously, the authority will.
So, okay, and
Right.
probably
Yeah.
because in the same department,
My lord.
the similarly situated person, the case of the similarly situated person has already been considered. And in that case, if his case is not considered, then he probably will be prejudiced because there's seniority will affect.
Lawsuit, they are not of same category.
No, same category, but then,
They are different lawsuit.
okay, okay. Hmm.
The post is different also, not.
Positive, okay, okay. Hmm. If the department issued person to this order, similar order, probably department will consider. So we'll give that direction that.
My lord, my lord.
With that
granting timeline, my lord.
It's a prayer of the prayer made in the writ petition.
Mhm.
It says the writ in the nature of mandamus should not be issued directing the responsible authority to constitute a review DPC. To consider the case of the petitioner
Yes,
for
sir.
promotion to the post so and so with effect from so and so.
Mhm.
This particular date is not correct lawsuit. So therefore lawsuit, just my only proposal is that lawsuit, the particular date may not
Which,
be given.
which,
Date may not be given.
which date is not correct according to you?
Lawsuit is
For prayer portion,
prayer-
page
prayer
28.
lawsuit. So for seeking direction to
A.
constitute a review DPC to consider the case of the petitioner. To that extent, it's okay lawsuit.
Mhm.
Because and here with effect from the particular date.
Okay, 12/8/16.
So what I'm pointing out, lawsuit,
So this may not
in
be.
place of the date lawsuit,
Yes, yes.
lawsuit may lawsuit direct as per the law lawsuit.
No, his claim is 2017, but then here your prayer is 2016.
That is based on my officiating.
Okay, okay, okay.
Officiating.
That cannot
So
be.
therefore, lawsuit
Okay, so let the department consider.
Yes, department.
Instead of putting this date in.
Yes, yes, yes.
Let the authority decide as per the law.
Okay.
Considering length of service, ma'am.
The time frames can be given, no objection on that. At
Okay.
least 4 months.
Then what I'll do, because this is not a similar case, not a similar category.
Not as, but
But then the,
retrospective, but reviewing the
yes, yes.
that part.
So what we'll do is we'll fix one date for delivery of order.
My lord, my lord,
Okay.
my lord.
Mr. Hidalgo, Planning Council for the petitioner. Also had Mr. Estapin, Learned Senior Government Advocate for the state respondent number
1 to 4 days.
1 to 4 staff, para. Then in that case, it will be, CAB only.
CAB.
Okay. The hearing concluded. Judge manager. Okay.
Problem.
My lord, that judgment already referred the decision, but if required, I have the judgment, other judgment also. This, the already referred, my lord.
Already referred.
Yes.
Judgment of which? This court?
No, Supreme Court, my lord, regarding.
Okay. Already referred, yeah.
Yes, already
You give
referred.
that also just.
Regarding counting of seniority, my lord, in officiating service.
I just tick mark the
Yes.
relevant paragraph.
Pre-judgment, my lord.
Have you marked?
Yes, my lord.
Okay. Item 15, no? Okay.
Deeply applied.
Item number 16 and 17.
My lord, I'm appearing on behalf of K. Lolen for petitioner and item number 16. My lord, we have recently received affidavit filed by state. So we need 3 weeks time to reply.
Okay. Or Mr.
J.
Land and Council appearing on behalf of Mr. K. Lolen, Land and Council for the petitioner. Also have Mr.
K. Dangan.
appearing on behalf of Mr. M. Kato, Land and DSGI. Staff, Mr. Oh, you are for?
Item number 17 for petition.
Okay. For in item 17, you are for
Petition.
petitioner. Okay. Oh, you also have you also received affidavit? Are you also going to, huh?
I'm not aware of because the leading counsel is the other court.
Okay. Mr. So-and-so. Land Council, appearing on behalf of Mr. K. Lolen, Land Council for the petitioner. Sami said he had just received the copy of the affidavit in opposition filed by the respondent and wish to file affidavit in reply, therefore for which he prays for. How much time you said?
3 weeks.
3 weeks time. Okay. The prayer having not been objected to by the council, Land Council for the respondent is allowed. Stop. List the matter after 3 weeks. So Miss Somo, Land Council for the petitioner in item 17 is also present. Okay. After 3 weeks. Okay.
Item number 21.
Item number
21.
I am declaring on behalf of State Information Commission, respondent number 1 and 2.
So this, no, you have not yet filed affidavit in opposition.
Yes, Doctor.
Are you praying for some time?
Yes.
Okay. How much time it will take?
Doctor, for more than 4 weeks.
Okay. Say more than 4 weeks is 3 years.
No.
How much is more than 4 weeks? 4 weeks. Will say. Who is for? Petitioner in person. Okay, none appears on behalf of the petitioner on call. Staff, huh? Miss-
For the petitioner.
Oh, you are for the petitioner?
Yes, my lord.
He is seeking some time to file
Yes,
affidavit.
my lord. By order dated, my lord, 4/2/25, my lord. The records were called for by this honorable court. Yes.
Record. Have we received record?
No, Lord.
Hmm?
He has to produce the record. He has not produced. Now the council has said, at that
Council was to
Yes.
produce.
yes. Oh, that was Mr. Soikia was the senior council.
Okay.
Now the standing council has changed, my lord.
Standing council change. You are standing council
Yes.
for the RTI.
Yes.
Okay. What is your good name? You said
B Poyam.
B.
B Poyam.
Your name is there.
B Poyam. POYOM.
Yes, yes. He's
No.
there, man. His name is there.
Your name is there.
Yes.
Okay. Okay. It's there. I thought. Poem. Mr. B. Picha, Land Council for the petitioner. Staff. Mr. B. Poem, Land Standing Council for
Information.
KPIC. Prays for further 4 weeks time. He is seeking 4 weeks time
Yes, sir.
to
Got it.
file affidavit in opposition. And also to produce record also,
Yes, my lord. Scan copy.
and also to produce scanned copy of the record. Stop, huh? The prayer so made by the Land Council for the respondent has not been objected to by the Islamic counsel for the petitioner is allowed. Please stop. Please pray for Kama list matter after 4 weeks. Okay.
Obligation.
Lordship, item 22 is the election petition.
Okay. So
Is the last.
what if, so what? Okay, no problem.
It's there for hearing.
Okay.
Paper.
Have you received the paper
I
book?
got one.
It's a
Correct.
complete copy, rectified. Okay. All fixed for the
Hearing.
fixed date for hearing. Okay.
Yeah.
Mr. Yasin Johnson, petitioner in person. Stop. I've also heard Mr. S.K. Deoring, Islamic counsel, appearing for the respondents. There's only one
Respondent number one.
respondent number 1. Is there any respondent number 2 also?
They are, but there is an expert over there.
Okay, respondent number 1. Stop. Mr. Johnson, Lanet,
Respondents. The DC was one Sachin Rana. I appeared for him. I filed an affidavit
okay,
in the contempt saying that the case is for review. We had filed, the state had filed and review.
okay,
And thereafter, this contender, Sachin Rana, he was transferred out of the state.
okay,
We filed another affidavit saying that I have been transferred because it was during the pendency of the review.
okay.
That now the Mihin Laling case has been settled
Mm-hmm.
and that the review has become infractions.
Mm-hmm.
Now they have included the new incumbent.
Mm-hmm.
I don't have the name.
Mm-hmm.
And my name is no more reflected.
Okay,
So in fact, I am no more required. It is the new incumbent who.
unless engaged.
Yeah, and for the new incumbent.
Okay, new incumbent,
Yes.
you have been engaged.
Yes, sir.
Okay.
I need. My lord, one moment, my lord.
Mm-hmm.
The only simple direction was that from this honorable court was to, my lord, direct the respondent, that the deputy commissioner to my lord, pay the solution. Of course, deputy commissioner won't be paying from the funds of the deputy commissioner. The only thing that has to be done by the deputy commissioner was simply to forward the calculated solution with interest to the requiring authority. That work will take only 5 minutes. Now it's 3 years to do that one. What they are doing is, those we have filed the application, submitted the judgment order of this honorable court. What the deputy commissioner does is sends it to the director who doesn't have any connection with the land acquisition process.
Take this and then
Why, I don't, 3 years, how? That's
if
too
it
long.
is so simple, then I think you need to inform the new incumbent. Review is also no longer, isn't it?
She also, previous deputy commissioner did the same thing, my lord.
Mhm.
Instead of forwarding the matter to the requiring authority.
No, at that time, because they were also waiting for the review also, since they filed review. Now review is no longer subsist. So I think you need to inform that these are the simple things they need to do if it is
Very
possible.
simple thing, man. Instead of forwarding to
let
director,
them-
it has
let
to
them
be
comply
forwarded
now.
to-
Let them
That's why,
comply
my
now.
lord, the.
Yes, sir.
Okay. Hard, Mr. Itapo, Islamic counsel for the petitioner staff. So your name now will be,
In fact, in the course title also, that only R1 has been mentioned. Are you Sachin Rana?
now new, have you implemented?
Yes, yes.
Already implemented.
Yes,
Okay.
yes. It's already been impleted.
There is no specific order to delete my name. That may be deleted.
Okay.
My lord, let him remain in the matter, my lord.
Oh, no.
No,
Let
that will be remained, but his name, his name probably.
No, my lord, because this, he ought to have forwarded the matter, my lord, at that point.
Okay.
in time.
No, my lord.
So-
At that point of time, the state has filed an review. Review was pending. Review on the ground that Mihin Laling case is pending before the Supreme Court.
Now, during the pendency of the review, Mihin Naling case came up, came to be disposed of. Review also became infraction. And before the Mihin Naling case and the review became infraction, infraction, the incumbent was transferred out. The question of he being deliberately disobeying the honorable court's order does not arise. Now this contempt is between the court and the alleged contender. Now, at that point of time, there was no deliberate action on the part of the DC.
Okay.
So now it is after the disposal of the main learning case, it is the new incumbent who has to take the steps according to he has to follow the direction.
With that regard, I can simply, my lord, it's up to the court, my lord. If my lord, he can convince the
what
court,
we'll do,
but he has no role, then it's up to the court, my lord.
what we'll do, we'll keep it for the timing till the next date. Next date we'll clarify.
Because
Because in any case, by the next date, they will, we expect that the new incumbent will file their affidavit.
Yes, sure. That was not required actually. She should have done it, my lord. As I said, it will hardly take 5 minutes to do that work, my lord.
Mr. N. Ratan, learned counsel who earlier appeared on behalf of the alleged contender, Mr. Sri Sachin Rana, submitted since he has been transferred from his
From SEPA, my lord. The asset
from SEPA to out of the state.
Yes.
He no longer represent the respondent and any staff. The further submitted in his place, new incumbent in place of the alleged contender. Some other person. New incumbent has joined as DC SEPA, who has already been implemented as respondent number 2 or 3. 2. Yasawani.
Yes.
Okay. Okay, Yasaswani.
B.
Therefore, his name may be struck from the court statute. However, okay. So his name will, according to you, his name should not be struck off now.
But
Okay.
the incident,
Let us see till next date, okay? Because you say that prior to before he is liable, he has already been transferred. Now after he has been transferred prior to this order, and then after this order, Milani's order, the present incumbent is responsible for. Okay, Mr. Ariram, Learned Counsel, appear on behalf of the respondent number 2. Put appear on behalf of the respondent number 2 and praise that he may be granted 2 weeks time.
2024, I have been transferred out.
Oh, then say way back in the year 2024, huh? Okay. Now Mr. Riram's case, and praise for 2 weeks time to
24,
go through the petition and to file affidavit. If so, advise staff. Response affidavit if required. Staff, the prayer is allowed. List a matter after 2 weeks or 3 weeks. 2 weeks.
3 weeks, Your Worship.
Okay, 3 weeks. Okay, 3 weeks.
Since 2023 matter is pending.
Okay, 2 weeks. 2 weeks.
Yes, Your Worship.
Okay. For a time being, let us give next time. 24, otherwise not required. 24.
My lord,
Please,
that's why
24.
fairly submit is up to the court, but
Okay.
I submitted.
Then in view of the, then after denounce, in view of the above. And as pray for comma, the name of Mr. N. Ratan.
The village container, Mr. Nitin
Who, Line Council for the alleged container Sachin Rana. No, alleged container also, his name cannot be, let it be remain, because that cannot be removed. Even if it is removed also,
Then observe that the alleged container number 1 is no more required.
that we can't say at the moment.
Because long time back, 2024.
See, at the time of disposal, probably that will be clarified. Don't worry about that. And then since you are not, no longer, you will not be appearing, probably it will go just like that only. Because if next time, if he clarify
Yes.
the responsibilities,
Yes.
liabilities, then probably your name automatically will go. Okay, keep it that
Yes.
like that, huh?
Objection.
Okay.
Item number 24.
Your Lordship, I'm for the respondent number 4, DC, who is the performer responding there.
Okay. So what,
Department of the food and supply, food and civil supply.
affidavit not yet filed? How much time?
Lordship, there is a standing council for it,
Standing counsel for?
food and civil supplies. Department.
Okay, you are for
I'm for this year.
state, okay. Who is for the, whether the standing council appeared earlier?
Tagum Jammu used to represent the department.
State is respondent number
For 4.
4. Director, food, civil,
For it,
civil supply.
Director of Civil
Four,
Supply is
okay.
respondent number 2.
Okay. Mr.
T legal for petition.
None counsel for the petitioner. None appears on behalf of the respondent number 1 to 3. Miss Sangita, land counsel, land government advocate, he is present on behalf of the respondent number 4. What about the private respondent? Have you taken steps?
Lord, I'm for the petition.
Are you filing, Mr. Sangita, are you filing affidavit?
no, Your Lordship.
Okay. The private, what about the private respondent?
Lordship, I'm not aware of that, Lordship.
There are so many private respondents.
Yes.
50 means 46. Just a minute, who appeared earlier? Mr. Padu, B. Padu appeared. Not in the sentence, none appear on behalf of the private, sorry, respondent number 1 to 3 and private respondent number 5 to 50 staff. The record, the office note reflect that the respondent are yet to file affidavit in opposition. No. Okay. In view of the above, and in absence of, in view of the above, the respondents are granted for a 3 weeks time to file counter affidavit. If so advised, huh? Okay. Publish the matter after 3 weeks. Okay.
Much always.
Item number 25.
Okay.
Yeah,
So-
as per instruction, Lordship, the amount has been already released to the petitioner also.
Not release, complied.
Complied.
Okay.
This is ex gratia compensation to the petitioner,
Okay.
50 lakhs also. This order is of 5 February 2026 also.
Have whether the petitioner has received,
Still we are not informed.
not informed.
Yeah. So like,
We'll get it listed tomorrow that you confirm from your client.
yes, sir.
Okay, otherwise you will,
Oh,
so
yeah.
that we close it. There is an order. Well, okay. Mr. Estapin, Land Council appearing on behalf of the respondent number 1 and 2. Submitted the order of this court dated. When was the date? Order and direction of this court dated 21/1/2025 has duly been complied with, and the money and the payment of ex gratia compensation has already been released to the petitioner. This is okay. In compliance of the judgment and order dated 15/12/2025, we'll change this, huh? Pass in WA number 16/2025, arising out of WPC number 459 AP 2023. However, Ms. Dirilo, appearing on behalf of the petitioner, submits that she has no information and prays for a daytime to obtain instruction in this regard. Stop. The prayer is allowed. List the matter again. We'll list Friday.
Oh, no.
Okay. As prayed for Kama, list the matter again on Friday. Okay.
Item number 26.
None appears for the parties on call. Released it after 2 weeks. Okay.
Item number 27.
Similar order. Oh, Paul, Mr. Oh, not audible.
Malad, am I audible now?
Yes, yes. Yes,
Malad, may I pray that this may be listed again on 19 because respondents, they have filed an affidavit. We might have to close it.
Okay.
I'll
Yes,
just
sir.
go through the contents and then next week.
When you say Friday?
On Friday also or on 19th because other cases are also fixed. On Friday also we can.
Okay, Mr. T. Patil, Land Council for a petition assembly states the respondent has filed affidavit and on perusal of the affidavits, is submitted this he may also pray for closure of this petition. Therefore, we pray for listing this matter again on Friday. Prayer allowed, list it accordingly on Friday again. Okay.
List
the matter again on Friday, huh? Write the date. Okay.